students under the supervision of an adjunct faculty member. And the problem was written for the Estrella competition that we do in Puerto Rico. And so I've actually seen schools around the country do this competition over a weekend in federal courthouses down in Puerto Rico. And, you know, we put in all the work to write this problem, and we fixed a few of the little tiny problems, and we use it again for this competition. Now, what does this remotely have to do with her? This is the coach of the Estrella team. So, so you have people that you know a lot about this competition, this problem. Let's say. Although Lauren is new at the Estrella competition, and I guess one last thing I'll tell you: why is the problem what it is? Alberto Estrella is a proud alum of this law school. He wanted to start the competition about 7 or 8 years ago. He funds it, and his biggest client is Home Depot. And Home Depot is a veiled reference to Cost Depot, and most of the problems are based on a case that Alberto has actually come across in his many years of representing Home Depot. So that's how we got to here. I'm going to turn it over to Lauren, and then we're going to begin. Lauren is a former public defender here in D.C. And has coached our teams to championships and national competitions, et cetera, et cetera.
Well, good morning, everyone. I'm super excited to see your presentations and hear your arguments. I won't speak much. As Dean Johnson said, I was working as a public defender here in the District of Columbia in the trial division for the last 7 years. And since then, I've moved into policy work. I now work for a nonprofit called the Justice Collaborative, where we do criminal justice reform policy work, focusing largely on local elected officials, often prosecutors, trying to help them develop less carceral policies. I love mock trial. I've loved it since high school, college, law school, and I am excited to be working with the Estrella team this year. I worked with the Tyla team the year before last, and we had a great run, so I'm really excited to see what you guys have got. So with that, I think we should just get started. So calling the case of Desi Fortunato versus Cost Depot Incorporated.
Your Honor, Daniel Helmick representing the plaintiff Desi Fortunato, along with the co-counsel Matilda Piana.
Good morning, Your Honor. My name is Jessica Mugler. I'm joined by my co-counsel Madison Cohen, and we represent the defendant, Cost Depot.
Before we begin, are there any preliminary matters?
Before we attend to housekeeping, we would like to tender to the bench a copy of the jury verdict form, local rules, complaint, and jury instructions.
Any other housekeeping matters?
And yes, Your Honor. May we have permission to move freely about the well?
Yes.
And may we assume that the jury's been sequestered?
Yes.
May we have permission to approach, or must we ask permission to approach all witnesses?
You don't need to ask.
And then, may we assume that the jury is constructively sworn?
Yes.
And would you like us to address yourselves or a constructive jury in the jury box?
You can address the court.
Your Honor, defense has no more housekeeping matters. We're ready to proceed.
Okay, motions in limine?
Yes, Your Honor. Plaintiff would like to exclude any mention of Diego and Desi's past relationship because any inference of such would be used to prejudice the jury, and there's no support for such an inference in the record. Furthermore, there's no narrative relevance to the inference because a jury could reasonably infer that Desi leaning into Diego could possibly upset Felix without any knowledge of the prior relationship pursuant to 403.
Any response from the defense?
Yes, Your Honor. We believe that the mention of Diego and Desi's relationship is extremely probative in this case. The relationship between Desi and Diego points to a stressor that Felix Fortunato was experiencing on the day of the event, which is highly probative to his health condition this day.
Any response?
As mentioned earlier, a jury could reasonably infer that Felix would be upset with seeing Desi lean into Diego without having any knowledge of a prior relationship.
May I respond? There will be the opportunity to discuss this with Ms. Desi Fortunato during direct and cross, and she will have the opportunity to explain the situation to the jury. But we do believe that this is an important and probative information and should be included in today's trial.
I will leave it for the testimony and consider if I should allow it or perhaps give an instruction.
One for the motion, then,
Yes.
Your Honor. We would like the court to strike from the record any mention of Mr. Felix Fortunato missing his medication at any time. Pursuant to Federal Rule of Evidence 404, evidence of a character trait used to say he acted in a particular way in any situation is not admissible. And in this instance, any evidence that he has missed past dosages would be used to imply to the jury that he missed dosages on that day and that he acted that way on the day of his death.
May I respond?
Yes, Your Honor. 404A covers character evidence, as I believe this motion is being brought under. Character evidence covers character traits or personality traits. Missing a dosage of medicine is not a character trait. It doesn't point to any personality of Mr. Fortunato. It's a specific act. And we further believe that it is very probative in this case to pointing to his health conditions on the day of the incident.
What about counsel's argument that it suggests he's not properly caring for himself, that he may be someone who is not, the character trait is not being someone who's attentive to taking care of himself?
Your Honor, we don't plan on making the argument that he is not taking care of himself. If anything, we will point to the specific act as merely decreasing his health on that specific day in question. We don't mean to make a propensity argument of him missing dosages in the past and therefore he has missed the dosage today.
Any response, counsel?
Your Honor, counsel described how they would respond, saying that they would use it to infer that he acted a certain way on the day, which is impermissible under 404, and therefore we believe that it should be excluded.
At this point, I am inclined to exclude reference to it. I'll allow you to rebring it if you have, you believe some foundation has been laid that changes my mind. Anything further?
Yes.
Okay.
Your Honor, we move to exclude a portion of the voicemail left by the Cost Depot manager, Tomasa Machado, to the plaintiff, Desi Fortunato. Would you like a courtesy copy for the bench?
Yes.
Let the record show I'm showing opposing counsel. Your Honor, the pertinent language that we would like to exclude is the last 3 lines of the top paragraph. Needless to say, I am not so sure we will be doing any more axe throwing at Cost Depot. I really wish we'd had a better first aid kit on hand. I'm taking care of that, so don't worry. Your Honor, we would like to exclude this language under Rule 407, subsequent remedial measure. This statement was made after the injury occurred to the plaintiff, Felix Fortunato, and we believe that this statement can be used to show that a subsequent remedial measure was taken place.
Yes.
Your Honor, permission to respond?
Yes, please.
Under 407, it can also, a subsequent remedial measure can be used to show control, which is what we would be using the voicemail to show Tomasa Machado, the store manager's control over her employee. We'd be willing to stipulate taking out the line, I'm taking care of that, so don't worry, as being really the only part that shows the subsequent remedial measure. But as to the other 2 lines, we'd be using that to show the control over the employee, Jamie Gonzalez, during the axe throwing event.
May I respond?
Yes.
Your Honor, we believe that this language could be used to unfairly prejudice the jury to show that if Cost Depot would have done these things, then this injury would not have happened. And that's exactly why this rule is in place, is to prevent statements that occurred after the fact from convincing the jury that if they would have happened before, something would have changed. Hindsight is 20/20, and to say that this statement exerts some sort of showing of control I don't believe that the statement does that necessarily. I believe this is more of a statement that happened after the injury and could be used to show that these actions should have taken place beforehand.
Are you conceding or contesting the ability to control?
No, Your Honor, we're not contesting the ability for the manager to control her employee.
Okay, given that defense is not going to be contesting that, I think that it could be more prejudicial than probative, and so I won't allow those portions that the defense is asking to exclude.
One more motion to eliminate, Your Honor. The defense also moves to exclude the supplemental memo from Tomasa Machado, the Costipo manager, to Costipo's legal division, as it is protected attorney-client communication under Federal Rule of Evidence 502. Would you like a courtesy copy for the bench?
Yes, please.
Let the record show I'm showing opposing counsel the supplemental memo. Your Honor, as stated, this communication is privileged attorney-client communication, as it is between the manager of Costipo, Ms. Machado, and the Costipo Legal Division. In the Supreme Court case, Uptown Co. v. United States, the court held that low and mid-level employees were covered under the attorney-client privilege, where the communication was necessary to prevent or to in preparation of potential litigation. Now, Ms. Machado is an upper-level manager, so she fits squarely within the attorney-client privilege, and this memo was sent supplemental to a report that is meant to prepare for any potential litigation of the incident at hand.
Your Honor, may I respond?
Please.
Although this was sent to the legal division, we do not believe that this was prepared in preparation for potential litigation. We believe that Costipo uses such memos to better their practices and to prepare themselves for the future and to understand whether or not they should fire an employee or discipline an employee in another manner. And therefore, it is not actually in preparation for a trial. It is for their own purposes, for the improvement of their services, and therefore, we do not believe that it should be covered by the attorney-client privilege.
Can you point me to the part of the document or anywhere else that's the basis for believing it's not in preparation for litigation?
Court's indulgence, Your Honor.
Sure.
Your Honor, we believe that the portion of the axe-throwing demos, the background of the axe-throwing demos on the second page, specifically is not in preparation for the trial. It is simply, we believe that it's simply a demonstration of how Tomasa Machado runs her business, and therefore is an indication of how they might suggest that she improve her business, not and how she made the decision that she did, not in preparation for potential litigation here.
So are you saying that you would only be seeking to use the background portion of the memo to show
Yes, Your Honor.
information about the managerial role? Any response with regard to that?
Yes, Your Honor. The legal division of companies normally do not decide who is fired or how to improve a business. They work toward litigation and seek documents for potential litigation. Now, as I described, I do think this fits within attorney-client privilege for that reason. As far as the axe-throwing demo section goes, this is specifically aimed at the axe-throwing demonstration, which is the incident in question today. It doesn't describe how Ms. Machado normally does events or demonstrations or what her normal role is. It's a specific role in this case to the axe throwing demonstration.
Anything further?
There you go.
At this point, I'm going to allow the reference only to the axe throwing demos portion.
Defense has no further motions, Your Honor. We're ready to proceed.
Okay. First witness.
Your Honor, plaintiffs call Mrs. Desi Fortunato to the stand. Oh, apologies, Your Honor. Opening statements.
Okay. I'm sorry, that was my mistake. Opening statements. You may proceed.
Your Honor, opposing counsel, ladies and gentlemen of the jury, may it please the court, my name is Mathilda Piano, and today I, along with my co-counsel Dan Hellenick, represent Ms. Desi Fortunato, who asks that the court make a judgment against Costipo. Felix was responsible enough to manage his condition, but Costipo was not responsible enough to manage its axe throwing event. On July 14, 2017, Felix and Desi planned on having a romantic and fun night out. You will hear today from Desi, Felix's wife, how Felix loved his work and he ran his business diligently, and how Desi wanted to plan a nice new event for them to do together. And that's how Desi came upon the Facebook page of Costipo advertising its axe throwing event. It seemed like it was going to be popular, and so that Felix and Desi decided to make a night of it. They decided to go with their friend Diego, who had already planned on attending. They drove to dinner to their favorite restaurant beforehand. Once they were done with dinner, they drove over to Costipo. It was a hot and crowded July night. It was so crowded that in the event, people were standing on the sides of the demonstration area because they had to wait to even get into line. You'll hear from Desi that there was no barrier separating axes flying from spectators on the side watching. In fact, the only thing that was separating people watching axes flying and the demonstration area was a single line of tape on the floor. Felix stood on the sidelines, ready to take a picture of his wife when she threw her axe. And through all the commotion, Desi heard the instructor say, "Go." And she threw the axe, but it bounced off the target and hit Felix in the thigh. Understandably upset and bleeding through his pants after being offered some gauze and a single bandage from a measly first aid kit, Desi and Felix decided it was best for them to go home. Today, you will also hear from Felix's treating physician of over 27 years, Dr. House, who will talk to you today about Felix's rare heart condition, Grote's disease. Grote's disease weakens your heart, making it susceptible to jolts of adrenaline that could spike the condition, spikes that could lead to a silent, deadly heart attack. You will also hear from Desi that when they got home that night, Felix did what he would normally do to manage his condition when he would have gone through a stressful event. He called his doctor, rested, took an extra dose of his medication, and meditated. You will also hear from Felix's physician that on occasion, Felix would go to the hospital. And this is because going to the hospital could add to the stressors, running costly medical exams and being poked and prodded by doctors, that it was best sometimes for him to stay home so that he could rest. And you'll hear from Desi and Dr. House that Felix had been managing this condition for years, and that he was very well aware of the effects of stress on his heart, and that he worked hard to make sure that he could manage his lifestyle so that he could be as healthy as possible. But you will also hear from Desi today that as the couple was falling asleep, they joked about how much worse the incident could have been had Felix gotten hit somewhere besides his thigh. But the following day, Desi soon realized that the worst had indeed occurred, because Desi woke up the next day, and Felix did not. Desi realized that her husband had died in his sleep from a silent heart attack. Negligence, simply put, is the failure to act responsibly. So every time you hear the word negligence today, I want you to think responsibility. Who is responsible? Our burden today is beyond a preponderance of the evidence. And we take on that burden gladly, because we will show you that it is more likely than not that Costipo is liable for the death of Felix Fortunato. My co-counsel, after hearing all the evidence and testimony today, will get up and ask you to find Costipo liable for Felix Fortunato's death. Felix was responsible enough to manage his condition, but Costipo wasn't responsible enough to manage its event. And as a result, Felix lost his life, and Desi lost her husband and her family.
Thank you. Defense, opening statements.
Good morning, Your Honor, and members of the jury. The death of Felix Fortunato was a tragic event. It is completely understandable that his wife, Desi Fortunato, wants to honor his legacy and seeks to recover in some way. However, Costipo is the wrong target to aim at. Today, you will hear a lot about axe throwing. While thrilling in nature, axe throwing is a highly safe and trendy activity. Axe throwing has rarely caused injuries, especially when the participants pay close attention to instruction and demonstration. Axe throwing is a type of event that is supposed to be fun for the whole family. However, that was not the case for Mr. Fortunato. Felix Fortunato suffers from a rare and serious condition called Gross disease. Gross disease causes a high increase in the likelihood of a cardiac event during times of stress. On the day of his death, Mr. Fortunato was facing a myriad of stressors. When Mr. Fortunato walked into Costipo that day, he was already showing signs of a silent heart attack. He was sweaty, agitated, and flushed. Mr. Fortunato was distracted. He was on his phone. He walked too close to the throwing lane, and he crossed over that tape line. When his wife, Desi Fortunato, threw the axe, it ricocheted off the target and hit Mr. Fortunato in the leg. And while it is very unfortunate that Mr. Fortunato was struck by the axe that day, it is by no means the fault of Costipo. Costipo exercised ordinary care and took reasonable precautions at every step of the way in executing the axe throwing event. Costipo exercised ordinary care when they hired Ms. Gonzalez to lead the instruction, a certified axe throwing instructor. They exercised ordinary care when, after Mr. Fortunato was struck by the axe, they offered to call 911 and provide medical supplies. Costipo exercised ordinary care when they attempted to persuade Mr. Fortunato to seek further help. However, he refused. Mr. Fortunato was the only individual in the room that day who knew of the intricacies of his condition. And because of that, he is contributorily negligent in his own death for failing to seek further care. As you heard today, the plaintiffs have a burden to prove. The plaintiffs must prove to you, beyond a reasonable doubt, that Costipo was negligent. And that negligence directly caused the death of Felix Fortunato. The plaintiffs must prove to you today that it is more likely than not that Costipo was negligent. That means that Costipo did not exercise an ordinary care that a reasonable person would do in a similar situation. The plaintiffs will not meet this burden today because Costipo is the wrong target to aim at. However, if you do find that Costipo meets their burden, we will prove to you today 3 affirmative defenses. We will prove these affirmative defenses to you today by a preponderance of the evidence, meaning that it is more likely than not they are true. If you believe that even one of our 3 affirmative defenses are true today, then you must find in favor of Costipo. First, Jamie Gonzalez was an independent contractor. that means that Cost Depot was not liable for any of the actions of Ms. Gonzalez. Second, Felix Fortunato was contributorily negligent in his own death. This means that the actions or failure to act of Mr. Fortunato played a significant role in causing his death. And third, Mr. Fortunato assumed all of the risks involved with the axe throwing event that day. Mr. Fortunato chose to attend the event. He chose to stay at the event when it was slightly crowded. And most importantly, Mr. Fortunato chose not to seek further medical care after he was cut by the axe. Today, we will prove to you these affirmative defenses by a preponderance of the evidence. Today, you will hear from Jamie Gonzalez, the axe throwing instructor who led the event that day. Ms. Gonzalez will share with you a little bit about her experience in training. She will share with you about the instructions and adequate demonstration that she provided for the participants that day. Ms. Gonzalez will also share with you a little bit about her interaction with Mr. Fortunato after he was cut by the axe, about how she attempted to call 911 and provided medical equipment. Ms. Gonzalez will also share with you about how she tried to persuade Mr. Fortunato to go to the hospital, but he refused. You will also hear from Dr. Chris Turk. Dr. Turk is a renowned expert in the field of cardiology. Dr. Turk will share with you her analysis of the case, about how she looked at the facts and came to the conclusion that the cause of Felix Fortunato's death was by more than an axe alone. Today, the plaintiffs will not be able to prove to you that Cost Depot was negligent, and they will not be able to prove to you that Cost Depot's negligence was the proximate cause of Mr. Fortunato's death. And because of that, we ask that you find in favor of the defendant, Cost Depot Corporation. Thank you.
Now the questions.
Your Honor, plaintiff's call Mrs. Desi Fortunato, please stand.
You're sworn.
Good morning. Please state your name for the record.
My name is Desi Fortunato,
Why are you here today, Mrs. Fortunato?
because my husband's dead.
I understand this may be difficult for you, so if you need time at any point, please just let me know. Before we get into exactly why we're here, I'd like to talk about yours and your husband Felix's life together. How did the two of you meet?
Felix and I met at the gym back in 2012. I noticed him doing deadlifts, and I thought he was pretty cute, so I asked him out. And it was really fast. We started dating in January, and we were married in August. Super romantic.
Did you all meet?
Yeah, for about a month, and then we came straight back because we both had work. So
What did you do for work?
So I was at an IT company, or I was doing IT, sorry, for a company, and now I work in IT for a tourism company, and then Felix does his restaurant stuff.
Can you
Yeah.
tell me a little bit about Felix's restaurants?
So at the time, he was managing a seafood restaurant and getting this consulting business off the ground. He was kind of like a much nicer Gordon Ramsay on Kitchen Nightmares.
Can you explain for those of us who haven't seen Kitchen Nightmares what that entails?
Objection, Your Honor. Relevance? I don't see the relevance of Kitchen Nightmares to the case.
Your response?
It's simply a phrase she's using to explain exactly what Mr. Fortunato did for his work, which is highly relevant to the case.
Why is it relevant?
What's that?
Why is that relevant?
What he did, because it's important to note the amount of work that Mr. Fortunato put in, the stress that he may have been under in order to combat any of the defenses that may say that his stressful life and his work played any part in the role of Mr. Fortunato's death.
I'll allow it.
Sure. Restaurants would hire him to go in when they were losing money or they were losing customers, and he was kind of the problem solver. He would figure out if there was an issue with food, with management, with ambiance, and so he kind of would swoop in and save the day.
Was that work steady?
It was pretty steady. I mean, starting out a couple years ago, it was pretty sporadic, but he would get gigs from his friends and things like that. So by the time he passed away, it was really decent.
What were his hours like?
It varied contract to contract. Sometimes when there were bigger contracts, he would be gone a lot, which was annoying. But right before he passed away, he had this really big contract with a steakhouse, and so he was there a lot. But
Did you talk about that with Felix?
oh yeah, I wanted him around more, and the consulting life is a lot of work and then no work and a lot of work and then no work. So we talked about it after this steakhouse contract. He was going to take a bit of a break, kind of even it out, but the steakhouse contract was a lot. I didn't see him much, which is why I planned the state night.
Okay, I'd like to turn now to July 14th, 2017. What were your plans for that evening?
I had seen this axe throwing event on Facebook, and I thought it would be like a really cool, cute, like date night thing. We wanted to spend time together. We wanted to change it up, so we were gonna go out to dinner and then go to this event and just head home.
Was just going to be the two of you?
No, so I found out about it through Facebook. It was on like Cost Depot's Facebook, and our friend Diego had liked it or said he was attending or something, and so I'd commented, and that's how we found out about it. So Diego came with us for dinner for the event.
You mentioned you found out about it on Facebook. Would you recognize that Facebook event if you saw it again?
It would.
Let the record reflect I'm approaching opposing counsel with what has been previously marked as Plaintiff's Exhibit A. And approaching witness what has been marked as Plaintiff's Exhibit A. Mrs. Fortunato, do you recognize this document?
I do. It's the Facebook event for the axe throwing event.
And has it been changed or altered in any way?
No,
And is it a good copy of the event?
it is.
At this time, plaintiffs move to have admitted into evidence what has been previously marked as Plaintiff's Exhibit A.
Any objection?
Yes, objection, Your Honor. Under 403, more prejudicial than probative, we believe that this will prejudice the jury into thinking that Cost Depot should have known that 50 people were coming based off the Facebook attendees, and will confuse them to think that this was a for sure number, a positive 50 people, where Facebook events, people can say that they're going and not show up. This was not actually a reliable source to assume that from.
Would Your Honors like a copy?
Yes. Do you intend to elicit the number of people who said they are going?
We do, Your Honor, and we believe it is highly relevant for narration, for the narrative. It is important to establish how many people Cost Depot were expecting to come to the event, for how much space they gave for the event, and how prepared they were for hosting this event. And the number of people that who said they were planning on to attend that Cost Depot had prior notice of from their own opposing party statement, we believe is highly relevant to that issue.
Do you intend to establish through any entity of Cost Depot that they were aware of this?
Yes, we do, Your Honor.
So for the time being, I will allow its entry not with regard to how many people had said that they were going. And if you establish that through a different witness, I'll allow it.
Mrs. Fortunato, what about the event piqued your interest?
Well, the picture's pretty crazy, but it looked really fun. It looked like anybody could do it. There were a lot of exclamation points. It looked really out there and kind of different. It seemed like the sort of thing that would be a fun date night.
Even though you've never been to an axe throwing event?
No, the Facebook page basically said, no experience required, just closed-toed shoes, which we had, so it seemed like they knew what they were doing.
Now, I'd like to go back to what you did that day. You mentioned that you had dinner before. Where did you go for dinner?
We went to our favorite steakhouse, BLT Steak. Diego came with, had dinner. It was a good time.
What was the tone of the dinner?
I mean, it was pretty jovial. Felix got a little mad at the end. Not mad, but he went to the bathroom, came back, and I was leaning over looking at Diego's menu, and he said something a little snipey, but, you know, he gets kind of grumpy on his medication, so I brushed it off.
When in the evening did that happen?
It was like right before we headed over. We got our dessert, talked about it, like things were fine, got in the car around 6:15, headed off to Cost Depot.
You mentioned you had dessert. Did you have anything else that evening?
I mean, we had our dinner, we split a carafe of wine, the usual.
So after you left the restaurant, what did you do?
We got in the car, we drove to Cost Depot, we got there a little before 6:30, like right before the event started. And it was kind of a mess. There were people everywhere. We went to the check-in stand. It was just kind of a table. There was camping gear everywhere. I signed the waivers for us so Felix could finish up something on his phone because he wanted to be more present. And yeah, then they started doing, I filled out the stuff for us and they started giving the instructions. And
What were the instructions like, and who gave them?
the axe throwing instructor was kind of at the front of this like mob of people. She was making a lot of jokes. She threw the axe a couple times, making a couple, I guess, crazy axe throwing moves, was saying, you know, do it with your eyes closed. It was so easy. And mentioned she would say, you know, okay, go. And then you could throw your axe. It just seemed kind of jokey, like, oh, everyone can do this.
Did you see the whole demonstration?
Pretty much. There were a lot of people, and they were talking kind of in my way, so I might have missed a sentence or two, but, you know, okay, go.
Where were you when the demonstration was happening?
We were at the back. People were kind of really crushed in. There were these tables of stuff. There was a wall on one side, so people were just kind of all over.
So demonstration happens. What happened next?
So people started getting into line. Felix said he would take a picture of me first, and then we would trade out, and I would.
Objection, Your Honor, hearsay.
Your Honor, this is not being presented for the truth of the matters stated.
What do you anticipate the testimony to be about what Felix said?
About what Felix said? That he was on his phone for the work?
And what is the purpose it's being offered for, if not for the truth of that statement?
Simply to show that he demonstrated that he was busy with something, Your Honor. The fact that it's work is not important.
Permission to respond, Your Honor?
Yes.
Yes, the statement from the witness was that Felix said that he would take a picture of Desi. I believe that that statement is being used as the truth of the matter, that he was going to take a picture of Desi, and isn't just being used as he was on his phone and busy.
Yes. Go ahead.
Your Honor, opposing counsel will have the opportunity to ask Mrs. Fortunato these questions, as well as any members of Cost Depot or the staff that they wish about this. This is an unavailable witness who did say something to his husband, and we believe that it should be admitted.
But is it not being offered for the truth of the matter asserted?
That he was planning to take pictures. Yeah, we are not offering it for the truth that he did in fact take pictures. It's merely for the fact that he had said he might take pictures of her.
I'm going to exclude it.
Well, I was in line and he was not. And, you know, 2 or 3 groups, it was like 2 pairs of 2. The layout was really weird. People were just kind of crammed right along this little tape line. There wasn't, you know, a barrier or anything like that. People were just kind of milling about. People were throwing their axes. And I got up there on my little platform thing, and the instructor came over. She adjusted me a bit. went over, was talking to the other person, and she said, okay, go.
Before we get to that, you did in your deposition mark on an outline of the map of Costa Rica, that thing, where it seemed to you that people were positioned. Would you recognize that?
I would.
The record reflects, I'm approaching opposing counsel with what has previously been marked as Plaintiff's Exhibit B. Would your honors like a copy?
Yes. Thank you.
Mrs. Fortunato, do you recognize this document?
I do. This is the diagram I marked.
And is it an accurate copy of the diagram you marked?
It is.
And has it been changed or altered in any way?
No, it's not.
Your Honor, at this time, the plaintiff's moved to have what has previously been marked as Plaintiff's Exhibit B into evidence.
Any objection?
Yes, defense objects under the hearsay rule. This is an out-of-court statement being used as the truth of the matter for where the witness or where the witnesses to the event were standing on the day of, and it doesn't fit into the witness's present sense impressions as it was created days or weeks later in her deposition, not right after the event.
Your Honor, opposing counsel had the opportunity to make these objections when it was presented to Mrs. Fortunato at deposition. No such objections were presented. Furthermore, it will only be presented to mark where Mrs. Fortunato perceived people to be, not for the truth of where they actually were at the time.
I'll allow it.
Mrs. Fortunato, could you please hold that up so we may see and describe where you were standing? You thought you were standing at the time?
So I was on this platform here, right behind us. There were all these display tables and junk. This is a wall over here. The instructor is next to the other person's platform. The targets are up here. And Felix was standing right here behind the line, but it was just tape on the ground.
So was there a barrier between Felix and the axe throwing target?
No, just some regular tape.
Were there other people over there with Felix?
Yeah, it was.
Objection, Your Honor, leading.
Were there other people? Overruled.
There were a lot of people. This was kind of the only place you could stand was right up by where the targets were, because this is crowded with camping gear and tables and stuff, and there wasn't really enough room for the line, so everyone just kind of blobbed over in this section. Tons of folks.
Permission to retrieve your honor.
Yes.
So, Mrs. Fortunato, you threw the axe. What happened next?
It didn't stick to the target. It bounced off and went flying, and it hit Felix in the leg, pretty high up. I mean, there was nothing there, so. And he grabbed his thigh because his thigh was bleeding and it cut through his pants. And there were so many people over there, I had to push through people. He was yelling, I was yelling. The instructor finally came over. Felix was upset. She had this half-empty first aid kit. It had some gauze and some bandages. They didn't even have Neosporin that I could see. And we cleaned up the leg. He was upset. He was yelling at them. I was upset. The instructor kind of brushed us off. It looked like she wanted to get back to the event, so we decided to go home and take care of it home, rest, get out of the way. I think they'd started throwing axes again before we were even out the door.
So, it wasn't a major cut?
It didn't seem so at the time. I mean, it ripped his pants and there was some blood and stuff, but, you know, it was annoying, but we got the bleeding to stop with a little bit of gauze. We figured we'd go home, we'd take a shower. It didn't seem that bad.
So, you went home. What did you do next?
Felix was pretty, you know, he was sweating and upset, but he'd been sweaty before.
Objection, Your Honor. Speculation. I don't think the witness can testify as to Mr. Fortunato being upset, as she doesn't know what was going on in his mind. She can testify as to what her impression was of his demeanor.
Your Honor, she is testifying to her impression of Mr. Fortunato, and furthermore, Mr. Fortunato is an unavailable witness. An unavailable witness caused by the actions of the defense, and therefore we believe that she should be able to speak as to his mindset being his wife.
No, so I won't allow her to speak to his mindset. She can speak to what she observed. I think she was at the point of talking about seeing him sweating and having seen him sweat before, and that's all admissible, but I won't allow her to speak as to his mental state.
Please continue, Mr. Fortunato.
So we called his doctor just to check in. We wanted to make sure everything was okay because he has this heart thing. He had this heart thing called growths. That was a little rare. So we had his doctor, good friend. I think he'd been treating Felix for almost 30 years, and called in, checked in with the doctor just to make sure. The doctor said, take another dose of your medicine, meditate, take a nap. I mean, he'd been stressed before, and he would always take another dose, go to sleep, be fine. And the doctor said to come in the morning if he wasn't better.
Were you aware of his Gross disease before?
Yes. I mean, he never hid it or anything. It had always been there, but he managed it so well that it was never a problem.
Objection, Your Honor. Under 404, this is a propensity argument, meaning that the witness is saying because he managed it before, he can manage it again this time.
Your Honor, it's not being presented to demonstrate that Mr. Fortunato handled it this time. It's simply being demonstrating the truth of habit. When he would get stressed, he had a habit of doing these things, and he had a habit of handling it well, and therefore, under 406, it should be admissible.
May I respond, Your Honor?
Yes.
Yes, Your Honor. Defense does not believe that this represents a habit. If Mr. Fortunato was stressed so much as to incur a habit of bringing down his stress levels, then maybe the evidence could be elicited to show that, but I don't think the foundation has been introduced to show that this was happening regularly enough to produce a habit. A habit is something like when you wake up every morning, this is what you do.
I'll allow you to lay the foundation if you are showing that this is a habit.
Mrs. Fortunato, did Felix get stressed out in his life?
His job was stressful. So we'd been married 5 years. I felt like I'd seen it all.
And how? I'd like to move on. So after the phone call, what did you and Felix do next?
We did what we would usually do. We got ready for bed. We kind of joked about how, it could have been so much worse. I was still apologizing nonstop because I felt terrible, and he was like, it's just my leg. It could have been so much worse. He said it wasn't. We went to bed. He took his extra dose of medicine, like the doctor said. We figured we'd pop into the office just to get everything checked out in the morning, and we didn't.
What did you do that next morning?
I woke up before him, like I always do, and I was making coffee for us, like I always do, and he didn't come out into the kitchen when the coffee was brewing. So I went in to check on him. He wasn't moving, and I went in to kind of shake his shoulder, and he wasn't moving. And I called 911, and they came, and he died in the night.
No further questions.
Cross.
Fortunato, thank you for being here today. I understand that some of the questions I may be asking may be a little difficult for you to answer, so if you need to take a breath or take a minute before answering, please do so. You and Felix were married for 5 years,
Yes, almost 5.
and he used to manage a seafood place,
Joe's, yes.
but now he worked in consulting.
Yes.
And he took a pay cut for that job.
Objection, Your Honor. Relevance.
Your Honor, this is being used to elicit the stressors that Mr. Fortunato had in his life. We believe that a pay decrease could be one of the stressors affecting a silent heart attack.
I'll allow it.
So, Ms. Fortunato, he had taken a pay cut for that job.
I mean, consulting money wasn't regular, but yes, it was less than what he'd made at Joe's.
And additionally, you had had some conversations with him about his increasing workload.
Yes.
And you also talked with him about wanting to spend more time together.
Yes, because he's my husband.
And moving to the night of the event, you two went to dinner with Diego Kavarian,
Yes.
and you three shared a bottle of wine.
There was a carafe on the table, but yes.
And you three all drank the carafe of wine. And that's the same Diego Kavarian you used to date.
Objection, Your Honor. We'd like to renew our objection over Diego and Desi's past relationship for being more prejudicial and probative.
Can I have a proffer of how it's relevant?
Yes, Your Honor. If I may proffer, the witness, I believe, will testify that she did used to go on dates with Mr. Kavarian, and this could be a stressor for Mr. Fortunato in his life to witness his wife bringing an ex-boyfriend to their date night and witnessing what was a little bit of an awkward moment of them leaning in next to each other at the dinner table, and this could have flustered him and increased his heart rate, leading possibly to a silent heart attack.
Any response, counsel?
Yes, Your Honor. Diego and Felix had a relationship outside of the one that each of them had with Mrs. Fortunato. They were friends independent of Mrs. Fortunato through work, and they established that friendship long after they both started dating and after Felix and Desi Fortunato got married. This is far enough in the past, and through his previous actions, Mr. Fortunato had shown that he did not truly care about this, and therefore we believe it does not hold much probative value.
If I may respond, Your Honor?
Yes.
The plaintiff side can elicit the foundation for Mr. Fortunato being friends on his own regard with Mr. Kavarian, and that being the main relationship between the three of them. However, I still think it is very probative of the fact of Mr. Fortunato's stressors that that Desi and Diego did used to date. Just because Diego and Felix had a relationship outside of that doesn't mean that there couldn't have been another stressor, being the relationship that his wife had with Diego. It does not show that he wasn't stressed or worried about that.
I'll allow you to elicit on redirect the other factors of the relationship, but I do think it's sufficient to go to the jury.
So, Ms. Fortunato, that was the same Diego Kavarian you used to date.
We had been on a few dates. We weren't serious.
And Diego kind of leaned in next to you at the dinner table,
We were looking at a menu together, so yes.
but Felix saw that.
Yes.
And in your opinion, Felix seemed upset after that interaction.
I mean, he made a comment about it. I wouldn't say upset.
Would you say he was put off by the interaction?
I would say put off.
And you knew about Felix's heart condition,
Yes, we were married. I knew about his health.
yet despite his heart condition, you chose to go to the accident that night.
I don't see how his heart condition would have stopped him.
Despite the increasing work deadline, you chose to continue with the axe throwing event.
Objection, Your Honor. Counsel has not laid a foundation for what she posits as a work deadline, and therefore it should be stricken from the record.
I'll allow you to lay a more of a foundation. It might not be clear to the witness either.
Okay. Ms. Fortunato, you stated previously, just a few moments ago, that Felix had a work deadline coming up a few days after the event. Is that correct?
He was working on this steakhouse contract.
And you had had some conversations with him about his increasing workload.
Yes, it was a very busy contract. He was there a lot.
And then turning to the night of the event, a few days later, he did have a work deadline after that.
He mentioned it.
Okay. And despite that work deadline, you still chose to continue with the axe throwing event.
He wanted to go. I didn't drag my husband there.
But you still chose to continue with the event.
We decided to go, yes.
And despite Diego being there, you chose to continue with the event.
My husband knew Diego was there. He liked the comment on Facebook.
So you did choose to continue with the event.
Yes.
Now I'd like to turn to the night of that event when you got to Cost Depot. You signed a form when you walked in the door.
When we got over to the event, there was a sign-in table, so I grabbed the waiver form. Yes.
And you signed yours and Felix's name.
I did. I signed for both of us.
Would you recognize that document if shown it today?
Yes.
Let the record show I'm showing opposing counsel what has been previously marked Defense Exhibit 1. Would you like a courtesy copy, Your Honor?
Yes, thank you.
Ms. Fortunato, is that the form, the document you signed when you walked into Cost Depot?
It is.
And how do you recognize it?
I signed it. That's my name.
Is it a fair and accurate copy?
It is.
Are there any assertions, deletions, or omissions in the document?
No.
Your Honor, at this time, defense moves to enter into evidence what has been previously marked Defense Exhibit 1.
Any objection?
No objection, Your Honor.
Submitted.
Now, Ms. Fortunato, doesn't the first sentence of this form say that you assume all of the risks participating in the event?
Yes.
Permission to retrieve and publish to the jury, Your Honor.
Granted.
Now, Ms. Fortunato, after you signed the form, you watched the axe throwing demonstration,
Yes.
and then you went to take your turn axe throwing.
Yeah, I pushed through the mob of people there to get in line.
And now, Ms. Fortunato, we may be getting to some of the most difficult parts for you to talk about the incident itself. So again, if you need a minute, just take one. So you threw your axe.
When the instructor gave the signal to go, yes.
And Felix got cut.
Yeah, the axe hit him in the leg.
But to you, the cut didn't seem very serious.
We were able to get it cleaned up.
Objection, Your Honor. The witness is not a medical expert and is being asked to tender an opinion on the seriousness of a medical matter.
May I respond, Your Honor? Your Honor, I'm not asking the witness for a medical opinion. Lay people encounter cuts all the time. I'm merely asking for this firsthand witness to say what she thought of the cut, whether it was serious or not in her own opinion and her impression. I believe that as a layperson, not a medical expert, she can testify as to cuts, which we all encounter every day.
I think she can testify to her perception. It was also elicited on direct, and so I will allow that to continue.
So, Ms. Fortunato, to you, it seemed the cut was not very serious.
I mean, at the time, no. We were able to blot it with the gauze, and we decided we'd go home, reassess.
And in fact, in your opinion, the cut was not a problem at all.
I mean, I was really upset, and I was apologizing, and, there was blood, but it seemed like something worth going home over, not worth running into the ER. ERs are super stressful.
But the cut was not a problem in your opinion.
Not at the time, it didn't seem like it.
And you didn't call emergency services? You didn't go to the hospital at all?
Which question are you asking?
You didn't call emergency services,
Not at the time, no.
and you didn't go to the hospital on your way home.
No, we decided to check in with his doctor first.
Moving to when you got home, you saw that Felix was sweaty and white as, I'm sorry, I'll let you
He was
answer.
sweaty.
And he was white as a sheet.
He was pale.
And his pulse was also racing.
He was having, a fast pulse, yeah.
And he also seemed to you pretty agitated.
I mean, he'd been hit by an axe, so yeah, he was not thrilled.
And still, you did not go to the hospital.
We decided to check in with his doctor. It's what we had done every time he'd been sweaty and pale and stressed out before.
But you did not go to the hospital that night.
Not that night. Every other time, he just, slept it off, take an extra dose of medicine, and we'd reassess.
Thank you. No further questions, Your Honor.
Brief redrift, Your Honor. Let the record reflect, I'm showing opposing counsel what has been admitted as Defendant's Exhibit A.
Thank you.
I'm approaching witness. What has been marked as Defense Exhibit A? Mrs. Fortunato, did Felix sign this document?
No, I did.
Did Felix look at this document?
No, I did.
I'd like to direct your attention to paragraph B, about halfway down the page. Could you read that one?
Indemnify, hold harmless, and promise not to sue entities or persons mentioned in this paragraph. Arising all liabilities, claims arising from any way related to participants' participation in the event, except for those arising out of willful misconduct, gross negligence, or intentional torts of the above parties as applicable.
Will you call your next witness?
Plaintiff would like to call Dr. Angel House.
Okay. And Dr. Swan.
Hello, Dr. House. Hello. Please state your name for the record.
Dr. Angel House.
And what is your occupation?
I'm a primary care physician in my own practice.
Where did you get your medical degree?
I went to New Columbia State School of Medicine.
And are you currently board certified and licensed to practice in New Columbia?
Yes.
And how many years have you been practicing?
I passed my exams in 1975, so about 44 years.
Do you have any residencies?
Yes, I had a residency in internal medicine.
And how many patients are you currently treating, more or less?
Around 500.
Have you given any lectures?
I've mostly, not many, I've mostly focused on practicing medicine. I give occasional lectures on how to manage an individual practice to graduating medical students. But again, as I said, I mostly focused on practicing.
Do you have any publications?
Yes, I had a publication in the New Columbia Journal of Medicine on the effects of stress, healthy diet, and exercise in recovery from a heart attack.
And do you currently have any disciplinary proceedings against you?
Not currently, no.
In the past?
In the past, I had 3 disciplinary hearings, but the board agreed with me in all 3 cases and dismissed them.
What happened in your most recent one?
My most recent one, it was alleged that I should have referred a patient to a specialist. However, as I said, the board agreed with me and ultimately dismissed the case.
How long have you been treating Felix for?
I started treating him and his family when he was in his mid-20s, so about 30 years, almost 30 years.
And what did you treat him for?
Well, as his primary care physician, I treated him for a variety of things, but the main condition I treated him for was Grote's disease.
And how long did you treat his Grote's disease for?
I diagnosed him when he was 31, so 25 years.
Your Honor, at this time, I would like to tender Dr. Angel House expert witness in the field of internal medicine and Broad's disease based on her extensive education, training, and experience to testify in the field.
Any response or remarks from Laura Dewey?
Just a brief objection, Your Honor. We concede that this witness is an expert in internal medicine. However, the foundation has not been shown, and she does not have the experience to be an expert in Grote's disease.
Any response? Yes.
Dr. House was Felix's managing physician for years, treating Felix's Broad's disease, which is a rare disease, and treating it for 25 years. She, more than anyone, is aware of the effects of Broad's disease on Felix, as well as having published a paper on the effects of recovering from cardiac arrest with health and diet and medication.
I will allow it. Certainly, you can cross-examine on any deficiencies.
Dr. House, what is Broad's disease?
Gross disease is a rare condition that affects and weakens the heart. It makes patients more susceptible to a myocardial infarction or a heart attack when the heart is under strain. If patients experience a sudden increase in stress or adrenaline, they can, and the condition has not been managed, they can experience a sudden heart attack. But even when it is managed, if they experience a sudden spike, it often leads to what's called a silent heart attack.
And how did you come to diagnose Felix with Broad's disease?
When Felix was 31, he began experiencing significantly more stress in his personal and professional life. He began complaining of chest pain, shortness of breath, and fatigue, rapid heartbeat, and dizziness. I took his blood pressure and saw that it was very high, so consequently I drew his blood, and I ordered an EKG, chest x-ray, and a CT scan. As a result of these tests, I diagnosed him with Grote's disease.
And I'd like to expand upon these tests that you ran a little bit for the court. Why did you order a blood test?
So blood tests can show certain proteins and enzymes that are found in heart muscles. When heart muscles are damaged, such as during a heart attack.
Objection, Your Honor. Relevance, I'm not sure that the detailed descriptions of blood tests are relevant to today's case.
Well, Dr. House is an expert witness, and for the purposes of the lay jury, I think it is important to establish what these tests determine, also to show the process by which Dr. House was able to diagnose Felix with Broad's disease.
May I respond?
Yes.
Today, there's no question about how or whether Dr. House diagnosed Mr. Fortunato with Grote's disease. There's no question of whether he had Grote's disease, so it's not relevant to today's case to go through the process of his diagnosis.
I would agree, given that we are not going to, the defense isn't contesting that he had that condition.
I'd like to turn to Felix's treatment. What was it?
So managing Grote's disease is about enabling a patient to manage their stress levels. And so I put Felix on a strict and limited diet and a robust exercise regime. I instructed him to engage in various stress management techniques. In addition, I prescribed various medications for his Grote's disease and to help him manage his stress.
And was his treatment plan permanent or flexible?
It wasn't a definitive plan. We would adjust it as needed. So if Felix was experiencing more stress in his life, we would up his dosage, and I would advise him to engage in his stress management techniques. And if he was able to manage his stress and had less stress, we would lower his dosage.
And how did you keep track of his treatment?
I kept detailed progress reports.
And if I showed you those progress reports today, would you be able to recognize them?
Yes.
Let the record reflect I'm approaching opposing counsel with what has been previously marked as Plaintiff's Exhibit C.
Is it the full progress reports
It's all
or?
16 pages.
Okay.
Yeah. Dr. House, what have I just handed you?
My progress reports for Felix Fortunato.
And how do you recognize them?
They bear my signature on the bottom.
And are they a fair and accurate representation of those progress reports?
Yes.
Have they been changed or altered in any way?
I do not believe so.
Your Honors, at this time, plaintiff would like to move to have admitted into evidence and has been previously marked as Plaintiff's Exhibit C.
Any objection?
No objection, Your Honor.
Let the record reflect it's 16 pages. Dr. House, what medication was Felix taking?
He was taking gencenepin.
And what is johnsenopin?
It's the leading medication for the treatment of Goetz disease.
And how would you assess Felix's ability to maintain a healthy lifestyle?
Overall, he was very good at maintaining his health and his stress. He had cut out smoking. He had cut out various foods and alcohol, and he often would follow my treatment plan. As I said before, managing Goetz disease is a whole person approach, and so overall, I think he was very good at self-correcting, and he knew how to manage his stress levels.
And how would drinking alcohol interact with johnsenopin?
So it would depend on the amount of alcohol consumed and the amount of medication that the patient was on. But he didn't make a habit of, even if he would engage occasionally in a drink, he didn't make a habit of it, and I wasn't particularly worried.
And did Felix ever undergo any traumatic events?
Yes, in 2009, he experienced a car accident while on his honeymoon with his first wife. As a result of that, I believe he experienced a cardiac event.
And how did he recover from the car accident?
Very well. He reported that he was experiencing, he was lightheaded and was feeling a little dizzy, and so he went home, meditated, did some yoga, and took an extra dosage of his medication. He called me the next day, and we sent him for further testing.
And referring to your January 2011 medical report, how was his health after the accident?
If I remember correctly, yeah, he was doing great. As I said, he increased his yoga and meditation practice. He understood, on the basis of this and other reports, I believe he understood the importance of keeping to his treatment plan and of self-correcting. He knew better than anybody, how to manage his condition.
And as his treating physician, how did you interpret the significance of this event?
Well, it was the only time I believe Felix experienced a cardiac arrest or a heart attack over the course of his Goetz disease, and it was as a result of the car accident and the physical impact and the resulting stress from that. I believe it also shows that he was generally very good at managing his stress and knew how to self-correct, and that he could do so without going to the hospital.
Objection, Your Honor. Speculation. This witness is saying that she can be sure that Mr. Fortunato knows how to handle his stress, and she can be sure that in a different scenario he would not need to seek further medical care, but she can't be certain that that would be the case.
Dr. House is an expert and is giving her opinion as to the cause of Felix's death, as well as to his various stressors in his life and how they could have impacted it.
I don't think, it seems like testimony right now is not about causation, but about his ability to manage stress over a period of time. And so if you can lay more foundation as to why she would know that, then I'll allow it, but otherwise I'll exclude it.
Sure. Dr. House, how long have you been treating how long had you treated Felix's Goetz disease for?
Since he was 31, so 25 years.
And how important is maintaining a healthy lifestyle when on Goetz disease?
Very important. It's essential to balancing the stress and being able to self-correct when everybody has stresses in their lives. And so patients with Goetz disease need to know how to self-correct when that happens so that they don't aggravate their Goetz disease.
And how did Felix's recovery from the accident reflect on his ability to do so?
Objection, Your Honor. I still don't believe that the foundation has been laid as to specifically Mr. Fortunato's abilities. Dr. House has testified as to how important stress is generally for patients with Goetz disease and how stress management is important generally for patients with Goetz disease, but has not laid enough foundation as to specific times where Mr. Fortunato has done this to testify to his ability now.
I would tend to agree if you would like to ask more specific questions with regard to how this doctor has extracted information that would give her enough information to make an opinion about generally how he managed his stress. I would allow it, but at this point I would agree he made the foundation.
Dr. House, over your time treating Mr. Fortunato, did you have to talk to him about stress management?
Sure, we discussed his stress management on multiple occasions. specifically with the car accident. He called me the night of that car accident and told me the symptoms that he was experiencing, and that he had, as a result of feeling lightheaded and flushed, he meditated and did some yoga and relaxed generally and took an extra dosage of his medication and rested, and that he chose not to go to the hospital that evening because he was worried that the additional stresses and having to travel to the hospital would in and of itself cause some additional stress.
Turning now to the night of the X-ray incident, Dr. Hose. When did you last speak to Felix?
He called me the night of the incident on July 14th.
And what did he tell you?
He said that he was lightheaded, was feeling dizzy, and had a headache. He discussed generally that he had been injured and at an event, and that he was feeling a little flush at that moment. And so I asked him if he wanted to go to the hospital or if he wanted to come see me. I offered him to come see me immediately, but he thought that he could use his normal stress management techniques, and again didn't want to go to the hospital because of the additional stresses. So I instructed him to take a higher dosage of his medication, and we arranged for him to come see me first thing in the morning.
And when did you last see Felix?
About 4 months before the incident.
And referring to the first page of your report, how was his health when you last saw him?
When I last saw him, he was in excellent health. Although his heart rate and BP were a little higher than I would have liked to, he had increased his. He was doing his regular exercise and increased his exercise, and so generally I thought he was on the right track.
So, if Felix's health was excellent, in your medical opinion, what was the cause of Felix's death?
In my medical opinion, to a reasonable degree of medical certainty, I believe that although he was experiencing a significant amount of stress in his life generally, I think but for the axe throwing event, Felix Fortunato would be with us today.
Thank you, Dr. Hose. Permission to approach and read.
You may.
At this time, I'd like to publish to the jury what has been previously admitted into evidence as plaintiff exhibits.
I'll allow it.
Dr. House, you have had 3 prior disciplinary proceedings.
Correct.
And one of those disciplinary proceedings was because you did not refer a patient to a specialist.
That was what was alleged. They dismissed the case and agreed with me that it wasn't necessary.
And you also did not refer Mr. Fortunato to a specialist.
Correct. I didn't believe it was necessary.
And Dr. House, you've been practicing for around 44 years.
Correct.
And in over 4 decades of practice, you have only had 1 patient with Groth's disease.
Yes, it's a very rare condition.
And that 1 patient with Groth's disease died as a result of Groth's disease.
It was aggravated by the axe throwing event, by the injury that was caused to him, but yes, ultimately it aggravated his Groth's disease and led to his death.
And Dr. House, as you testified earlier, you diagnosed Mr. Fortunato with Groth's disease.
He was 31.
And you made a treatment plan,
Yes.
which included healthy eating,
Yes.
it included stress management,
Yes.
and also included a prescription for Johnsinofen.
Yes.
So you had explained to Mr. Fortunato the importance of stress management.
Yes.
And at times you changed his prescription levels because of stress.
Correct.
And Dr. House, is it recommended to drink alcohol while taking Johnsinofen?
It's not recommended, but as I said, as long as they're maintaining an overall healthy lifestyle, engaging in a drink or 2 is not particularly concerning.
And you had discussed drinking alcohol while on the medicine with Felix,
Correct, yes.
and you recorded that in your patient progress notes?
Yes.
Let the record show, I'm showing opposing counsel, what has been previously entered into evidence as Plaintiff's Exhibit C. And Your Honors, for your reference, we'll be looking at page 123 and 129 of the report. So, Dr. House, in this report, you recorded discussing alcohol consumption with Felix.
Yes.
So, it is safe to assume that Mr. Fortunato knew he was not supposed to drink alcohol.
Yes.
Yet he still reported to you multiple times of drinking alcohol.
A handful of times over the course of
permission to retrieve the report from the witness.
Yes.
Dr. House, do you believe that Mr. Fortunato was consistent in taking his medicine?
Overall, yes, I believe he was very good at taking his medication and engaging in his stress management habits.
But you cannot be certain that he always took his medicine.
Objection. I would like to renew my prior motion to not have any mention of Mr. Fortunato possibly was giving a dose of his medication in order to pinpoint that on the night of the event he may have not taken his medication under character evidence.
I think that the door has been fully opened by what was elicited on direct about how he manages his stress day to day. So I'm going to allow it.
So, just to be clear, Dr. House, you cannot be certain that Mr. Fortunato always took his medicine.
Based on my conversations with Felix, he regularly took his medication, but no, I was not with my patient when he took his medication, so I cannot be certain.
And prior to his death, Mr. Fortunato was late in picking up his prescription.
Yes, I believe he was a couple days late, but I wasn't overly concerned.
And Dr. House, the last time you examined Mr. Fortunato was March 3rd, 2017.
Yes, about 4 months before the event.
And when you examined him, you increased his medicine prescription slightly.
Yes, I adjusted according to what I was seeing.
And it was because his blood pressure was not exactly where you wanted it.
Yeah, it was a little high.
And Dr. House, the last time that you spoke to Mr. Fortunato was July 14th.
Correct, the night of the incident.
And as you mentioned, around 4 months had passed since when you examined him and when you spoke to him.
Correct.
And Dr. House, is it possible for patients with Groth's disease to experience changes and fluctuations in stress over time?
Certainly, it's possible.
So it would be reasonable that between the last time you examined Mr. Fortunato and the time that you talked to him, his stress levels could have changed.
So we discussed the symptoms he was experiencing on the night of the event and what had been generally going on and would be relevant to his treatment. And based on what I was hearing, I didn't think there was anything to be particularly concerned of, or I would have gone and seen him immediately.
But just to be clear, Dr. House, over 4 months of time, it would be possible for a patient to experience a change in stress level.
Many things are possible with a patient, but all I can say in the instance of Felix is what I know from based on our conversation with him and what I saw before, which is that he was generally on the right track and over the course of 25 years knew how to manage his stress.
But as an expert, Dr. House, it is possible for stress to change over time.
Yes, as I've said, it is possible, but I don't believe that's the case with Felix.
Just one last thing, Dr. House. You mentioned that Mr. Fortunato had a previous cardiac event,
Yes, in 2009.
and that was because of a car accident.
Correct.
And after that car accident, you were very concerned that Mr. Fortunato did not immediately go to the hospital.
Well, we discussed why he chose not to do so, and he believed that the additional stress of traveling, I believe it was over 100 miles to the local hospital, and the tests and the expenses of those tests, he believed would have caused him additional stress. And so he managed his condition well, and I think the results speak for themselves.
But you were concerned that he did not go to the hospital directly after the incident?
Sure, I was concerned generally about my patient's condition.
And Dr. House, it's true that the night you spoke to Mr. Fortunato on the 14th, you did not require him to go to the hospital.
I cannot require my patients to do anything, but we discussed, I asked if he wanted to come see me, if he wanted to go to a hospital, and he said that he really thought that what was best was for him to take an extra dose of his medication and relax at home. So we arranged for him to come see me the next day, and I thought that, based on what I knew, was sufficient.
So just to be clear, you did not tell him to go to a hospital?
I told him to do so if he thought it was necessary, but he said he didn't.
And Dr. House, it is true that the night where you spoke to Mr. Fortunato and told him he did not need to go to the hospital is the same night in which he died?
Yes.
No further questions.
Redirect.
Dr. House, Groth's disease is rare,
Yes, very, very rare.
and over time, treating Felix, how did you assess his ability to manage his fluctuating stress levels?
So we would adjust, as I said, his treatment plan as necessary. And Felix was very well aware of that. He understood the importance that Graves' disease was a very serious condition and how to manage that. And he knew how to, in the moment, self-correct when he was experiencing.
Objection, Your Honor. The witness cannot speak to exactly what Mr. Fortunato knew how to do in a specific moment.
Your Honor, Dr. House would speak with Felix about what he would do to manage his stress in certain events and when he was stressed out. So she has intimate knowledge of what Felix would do.
I'll allow you to rephrase the question just so that it's based on the information provided to her, what she can speak to.
Sure. Dr. House, based on your progress reports and your time treating Felix, how do you know how he managed his stress?
So when he would manage stress, he would sometimes call me or otherwise schedule an emergency meeting with me, or when he would come in for his regularly scheduled appointments, we would discuss how he was generally managing his stress, how he felt his stress was in his life, and whether it needed to be adjusted. And so I would remind him at times of different techniques that he could use if he was feeling stressed. He was an avid practitioner of yoga and exercised regularly, and we would discuss this during his appointments. And then, when he would call for an emergency, we would often prescribe him additional dosages of his medication.
May the witness be excused?
Yes. Any further witnesses?
No, Your Honor, plaintiff's rest.
Your Honor, at this time, as plaintiff has rest their case, defense moves for judgment as a matter of law, as there is no legally sufficient evidentiary basis for a reasonable jury to find in favor of the non-moving party, because they have not given proof that a reasonable person would have acted any more carefully than Cost Depot would have in this situation.
Any response?
Yes, Your Honor. We've heard testimony today that Cost Depot had an extremely crowded event, that they did not put up barriers in between where the people attending that event were and where the axes were being thrown. And we think, based simply on those facts alone, regardless of anything else that's been said, a reasonable jury could meet this very low burden of finding that Cost Depot was negligent in this matter.
I'm going to deny the motion at this time. You're asked to proceed. Is this the time when parties usually take a break? Okay. Then I'll allow that.
How much time?
The plaintiff has 50 minutes and 17 seconds remaining, and the defense has 32 minutes and 36 seconds remaining.
When would you like us back?
So let's take 5 minutes.
This won't count toward our time.
No.
Okay, yeah. You said plaintiff 15 minutes, and defense 30?
Plaintiff is 50 and, no, sorry, plaintiff is 32 and 36. Yeah. 32 minutes, sorry, there's Maddie's on the other side and.
Sure.
Okay, I was like. Yeah, the plaintiff has 32 minutes and 36 seconds remaining, and defense has 50 minutes.
Okay, thanks.
I heard 15, and I was like,
I know, I was like 15 minutes.
I was like, oh gosh.
Abby.
Should we take a little
Yes.
walk? I'm gonna fill up my water bottle. Okay, I'm gonna go get my water.
You're gonna go take our notes?
But that doesn't start for lunch. Oh, yeah.
I think I'm gonna skip.
Wanna walk with me?
No, maybe not. She totally blew us off earlier.
Good. Are you gonna come talk to us now?
But I think Phil has this, all I really need is the class.
Like, you
I'm trying to see that.
You're just a mere.
There's nowhere I'd rather be. Oh my god. Intelligent and making good points and like
Oh, I agree.
Yes, I do. I need to. Right.
well, the first
Oh my god. Did you skip it? She like,
Oh, she did great.
she was like,
Everybody else.
so far.
the drop was hilarious.
I was like, where's it going?
Yeah, true. We said it up. They were like, it was
You got it. I'm gonna go in out this way. Come back in.
The reason was just all my years of doing this. All the construction stuff.
Okay.
Oh, what time?
So can we move it to 8? I gotta go get some before.
Okay, let us spend both.
this is what
What is the
I need help with like drink ingredients.
Okay. So I'll stop at CVS and handle it. Okay. Oh my god.
I feel them already.
whatever that is.
Okay, I might need like ingredients.
Stepping out
Okay.
from a country home.
To be honest, I gotta go to Frank's. No, please let us spend it.
Honestly, I'm doing it just for me. I'm going right after. No tears like Jesse. Do you need like, do you need her ready to Oh, you can wait. What time? You have to do it at night. I'll go home, clean, and then I'll come back.
Yeah.
Oh my god. If anyone else wants to go there.
So I'll handle candy.
I have to go tomorrow and I choose
For wanting.
I chose the litigation. I guess that is basically from the years.
I'm glad. I don't know if we're gonna get to it. If we don't get to it today, on Monday, we're starting soccer.
Okay, yeah, I'll handle candy. Yeah, what do we want? Candy corn? I like candy.
Where are you?
You don't like candy.
Oh yeah, I was gonna ask
I'll put it in like one weird obscure thing.
I think she likes
Whatever you feel like it is. I don't care.
That would have been. No. You put it on your necklace so it's observed. There's only one.
I was like, you would mention it, start showing I know a lot. Right now,
We're like,
we're almost.
Men, like, it's we
Yeah, we did. It's his first show.
I was like, sir, you bring it on. It's so nice. Yeah.
What?
Yeah.
Yes.
We bonded earlier, man. How are you gonna come here and give us you? I know that was so rude.
We don't want to bond her back.
Like, yeah, that was. I can't believe he came in and like.
No, I don't know.
Originally supposed to be.
Obviously, I'm not the only one speaking to this empty crowd. What about me right now? That didn't take anything away from my moment. It didn't. It didn't. I mean, it was better. Gals be looking good.
And then I might do
It's been a day.
The plaintiff has 32 minutes and 36 seconds remaining, and the defense has 50 minutes and 17 seconds remaining.
Oh, yeah. Okay. We can begin again. Is everyone ready to proceed? Okay. Defense first witness.
Defense would like to call Jamie Gonzalez to the stand. Thank you for being here today. Could you please introduce yourself to the jury?
My name is Jane Gonzalez. I am the assistant manager of the Costa Depot Deli Counter.
Ms. Gonzalez, what was your occupation on July 14th, 2020?
I was working nearly full-time at Costa Depot, but recently just opened up my new axe throwing club, Bury the Hatchet.
What sort of training is required to be an axe throwing instructor?
There's no legal requirement, but I completed a 6-hour online training course, passed an exam while submitting 2 hours worth of video in order to complete my certification.
How many classes have you led prior to the event at Costa Depot?
About a dozen.
And were there any prior injuries or issues that arose at those events?
No, everything went perfectly.
Ms. Gonzalez, how did you get the job of leading the axe throwing demonstration at Costa Depot?
Well, Tommaso wanted to boost sales of Costa Depot's new camping line, so I offered to lead a promotional axe throwing demonstration for the store.
What were your typical job duties at Costa Depot?
I worked at the deli counter.
Did Costa Depot follow any protocol to allow you to lead the demonstration?
I had to sign an independent contractor agreement.
And in what capacity did you sign this agreement?
Through my company, Bury the Hatchet.
Would you recognize this agreement if you saw it today?
Yes.
Let the record show I'm showing opposing counsel with what has been pre-marked as Defense Exhibit 2. Would you like a courtesy copy for the bench?
Yes, thank you.
Ms. Gonzalez, what is this document?
This is the independent contractor agreement.
How do you recognize this document?
It's the agreement that I signed in order to put on the axe throwing event at Costa Depot.
Is this a fair and accurate copy?
Yes.
And have there been any assertions, deletions, or omissions to this document?
Not that I can see, no.
At this time, defense would like to move what has been pre-marked as Defense Exhibit 2 into evidence.
Any objection?
Objection, Your Honor. Hearsay?
Your Honor, this document is a representation of a legal act. It has independent value, aside from the fact that it is an independent contract agreement, and because it's a legal act, it is allowed to exceed hearsay. Objection.
I would tend to agree. Is there anything within the agreement that you think does not constitute the legal act itself?
No.
I'll allow it.
So, Ms. Gonzalez, according to this agreement, how are you compensated for leading the event?
I was compensated with $200 per event and then $10 per person who attended the event.
Permission to publish to the jury?
Yes.
Gonzalez, how many people did you expect to attend the event?
We planned the event with the expectation that 30 people would show up.
And how many people actually showed up?
36.
How did you know this?
I told everyone to sign a release agreement when they showed up.
Did Felix Fortunato sign a release agreement?
No, he did not. His wife signed for the both of them.
Ms. Gonzalez, what interaction, if any, did you have with Desi and Felix Fortunato before they signed in?
They rushed in late. They were standing nearby, so then I could hear them bickering. Felix seemed a bit sweaty, and he kept muttering
Your
some
Honor,
comments.
hearsay?
Your Honor, this is not hearsay. Ms. Gonzalez is merely inserting her opinion of the scene. She's just sharing her impression of the scene at the moment.
Why are her observations or her opinion of the scene? I'll take that separately. So it seems like she's making statements about what she overheard Felix saying. What is that?
So, Your Honor, this is important and probative information because it goes to show the state that Mr. Fortunato was in when he entered Costipo, which is very pertinent to the case because that is a part of the argument is that Mr. Fortunato was already experiencing certain stressors by the time he arrived at Costipo.
Okay, so you're not offering the statements themselves for the truth, it's for the stressors that they perceive, could have been a perceived stressor.
Yes, Your Honor.
Okay, and then I won't allow any testimony about opinion as to the stressfulness of the scene.
Yes, Your Honor. So, Ms. Gonzalez, what interaction did you have with Desi and Felix when they walked in?
Sure, they had rushed in late. They were standing nearby me, and I could hear them bickering. Felix kept making snide comments to Desi that anyone could have heard. He was also looking at his phone quite a bit.
And Ms. Gonzalez, what happened after sign-in?
I went to the front of the demo to start giving instructions.
And what did these instructions include?
I tell everyone to pay close attention to their surroundings and what I'm saying, especially when it's their turn to throw. I then asked the group if anyone had any questions.
And what happened after you gave your demonstration?
I gave a short demonstration, and then it was time for everyone to take turns throwing.
So, Ms. Gonzalez, when it was Desi's turn to throw, what were the other participants doing?
I did notice a group of participants that had crossed the line standing at the edge of the lane, so I yelled a warning to get back. Felix was one of the participants within that group.
Would you recognize a picture of the layout of the space we saw today?
Yes.
Let the record show, I'm showing opposing counsel what has been pre-marked as Defense Exhibit 3. Would you like a courtesy copy for the bench?
Yes.
Ms. Gonzalez, do you recognize this document?
Yes.
How do you recognize this document?
This is a diagram of the layout of the axe throwing demonstration area.
Your Honor, permission to use a demonstrative aid of the same picture that is before you.
Any objection?
No objection, Your Honor.
Your Honor, permission for the witness to step down from the stand to make use of the demonstrative aid.
I'll allow that.
Can you just angle it a little so everyone can see? Yeah, that's perfect.
Ms. Gonzalez, could you please mark where Desi Fortunato is standing by denoting a D with a circle?
Objection, Your Honor. This calls for speculation of exactly where the truth of the matter, and therefore it also hearsay of where Desi was standing, not for where the witness perceived Desi to be standing.
Your Honor, as was previously discussed, this is Ms. Gonzalez's impression of where the parties were standing, and she is just sharing with the court today her interpretation of the scene.
I will allow her to testify as to what she observed.
Ms. Gonzalez, could you please mark where you were standing by circling a J? And Ms. Gonzalez, could you please mark where Felix Fortunato was standing by circling an F? Thank you, Ms. Gonzalez. Your Honor, at this time, the defense would like to move into evidence what has been pre-marked as Defense Exhibit 3.
No objection.
It's admitted.
So, Ms. Gonzalez, where was Felix standing when he was struck by the axe?
He had crossed the line at the edge of the lane. He was too close to the target. He was paying more attention to his phone than his surroundings.
How did you direct Desi Fortunato to throw her axe?
I didn't. I started to count down 3, 2, and then noticed that the other participant had improper grip, so I yelled, "Hold it."
And what happened after you yelled hold it?
Desi threw her axe early. It then hit Felix.
How did Felix Fortunato react to the injury?
He was angry. He kept yelling at me and calling me names, but didn't seem particularly concerned about the injury.
And Ms. Gonzalez, why was it medical services called?
I suggested we called medical services. Felix just kept insisting he was fine.
Objection, Your Honor. Hearsay.
Your Honor, this is Ms. Fortunato sharing why she specifically did not call emergency services.
Okay, if it's being offered for the effect on the listener and not for the truth of the matter asserted, I will allow it.
So, Ms. Gonzalez, when you saw Felix's injury, what was your impression of the injury?
Well, he really didn't even let me get close enough to check, but from what I saw, it wasn't particularly serious. It was just a cut.
No further questions. Would the plaintiffs like to make use of the demonstrative as well?
Yes, sir. Ms. Gonzalez, you've worked at Cost Depot for 4 years.
Not that long, about 2 years.
It's your testimony today that you've worked at Cost Depot for 2 years.
2 years before the axe started that, yes.
But today, as of today, you've worked at Cost Depot for 4 years.
If that's the timeline, yes.
You've worked at the deli counter that whole time.
Yes, except for when I was independent contractor putting on axe throwing event at Cost Depot. But as far as full-time employment
You
with
were-
Cost Depot, I worked at the deli counter.
And you were at work one day when you saw that Cost Depot had a new line of camping equipment,
Yes, my manager informed me of the new line of camping gear.
and that camping equipment included axes.
Yes, that's correct.
You knew that the store's sales numbers were lagging behind the other locations.
Well, I didn't particularly know that. That would be more of a manager question to ask. As I
Is
said,
it-
I just worked the deli counter.
Yes or no? You knew that the store sales numbers were lagging behind other locations.
Again, my manager mentioned it.
So is it your testimony today that your manager had mentioned that the sales numbers were lagging behind and that you had knowledge of that?
Yes.
That day, when you saw the display, you went up to your manager, Tomasa Machado, and offered to do her a favor?
Yeah, I offered to leave a promotional axe event. I thought it would be a great way to boost my new company, Bury the Hatchet.
She agreed to hold this event.
She did, yes.
You created a Facebook page to advertise for the event on the night of the 14th,
I did. I thought it would be a great way, again, to showcase my new company.
and you got a huge response on Facebook.
Objection, Your Honor. As previously objected to, we believe that the use of this specific portion of the Facebook event is more prejudicial than probative. Just because there was a number on that event does not mean that that was the number that Ms. Gonzalez was assuming would be coming to the event that day.
Your Honor, we're not presuming to know what they were assuming. We're presuming we are just demonstrating what they could have, the numbers that they could have anticipated coming based off the Facebook event, which is highly probative of whether or not they were correctly prepared and responsibly prepared for the event.
And I'll allow you to ask if she had knowledge of the response that was on Facebook, especially given that she's already testified to how many people attended and how many she planned for.
Ms. Gonzalez, you created this event?
I did, yes.
Ms. Gonzalez, you used Cost Depot's Facebook page to create the event.
I did, yes.
The event said it was hosted by Cost Depot.
Yes, because as I mentioned, while I was doing it to promote my business as well, it was also a favor to my manager at Cost Depot.
You said you got a huge response on Facebook.
Yeah, there was a response.
Let the record reflect, I am approaching opposing counsel with what has been admitted as Plaintiff's Exhibit A. Approaching the witness, what has been admitted as Plaintiff's Exhibit A. Ms. Gonzalez, that Facebook event pictured a picture of a woman holding an axe above her head, aiming at a man standing in front of a
Objection,
target.
Your Honor. More prejudicial than probative. The description of this picture has nothing to do exactly with the event at Cost Depot. That's not a depiction of the actual space at Cost Depot. It's merely a picture that is being used to promote and attract people to the event.
Your Honor, this has already been admitted into evidence.
I agree.
Ms. Gonzalez, the Facebook page featured a picture of a woman holding an axe above her head, prepared to throw it at a man standing in front of a target.
Yes, that's what the picture looks like.
That Facebook event advertised that the axes being used were available at Cost Depot.
Yes, it does.
That Facebook event encouraged the purchase of said axes at Cost Depot.
Of course, as I mentioned, it was both a advertising opportunity for Cost Depot as well as myself promoting my new company.
The witness would please stick to answering my questions. That Facebook event said that the only items required for safety were closed-toe shoes.
Yes, and I believe it also says a shirt that allows full range of your arms during the throwing.
Is it your testimony that that says that it's required to have a shirt for your arms?
No, it says it's helpful.
Thank you. 50 people responded to the Facebook event saying that they were going.
Actually, more than 50 responded. In total, 50 said they were going, but as I said, we expected 30 people to show up to the event.
But 50 people did say they were going.
On the Facebook event, which of course isn't always true to the number of people that show up for things. People get caught up in the moment when they see an advertisement on Facebook and just click going.
And 25 further people said that they might be going.
That's correct.
And 134 people still had yet to respond to that event.
I think 134 people were invited in total.
134 people had still to respond to
Your
that
Honor.
event.
Relevance. Why is it relevant how many people she invited to this event when she's already disclosed how many she expects to come?
We're about to get to that, Your Honor. It's highly relevant as to how many people she expected to come if she invited almost 200 people to the event and only planned for 30.
I think that counsel has laid a foundation that he is not accepting her testimony as to how many she actually planned for. And so I think this is right.
Fewer than 30 people had participated in the previous 2 Cost Depot events that you had put on,
That's correct.
and you'd never taught a class before the 14th of more than 18 people.
That's correct.
You asked Tommaso Machado if you could have more space for the event.
Once I realized that 36 people had shown up, I did ask if we could have a little bit more space at the back of the room. She said that I had to work with what I had, and although I was a little annoyed, I really wasn't worried about it.
But you asked Tommaso Machado for more space.
Yeah, I asked if it was possible.
And Tommaso Machado was your manager at Cost Depot.
She was my manager as the deli counter employee, but not as myself coming in as an independent contractor for my axe throwing company.
And Tommaso Machado told you to make the space do with the space that you had been given.
That's correct, yes. And as I said, I was a little annoyed, but not at all worried.
And you had less space that day than you had had on the previous events.
Yes, just a few feet from the back.
And because she had added new display tables to the event area.
Yes, she did.
These are the display tables that she refused to move.
That's correct, yes. She didn't want to move them. And as I said, it was a little annoying, but I wasn't worried.
These are the display tables that you had asked to be moved.
Yes, I just asked for more room, not necessarily to move the tables, but it was fine.
Tommaso Machado told you that corporate was pushing her to keep those display tables there.
Sure, I mean, she may have mentioned something to that matter, but again, that would be more of a question for Tomasa as to what she actually was told by corporate.
But she did tell you that. She was asked by corporate to keep the display tables there.
Sure, again, she mentioned it.
And you were checking people in at the beginning of the event.
Yes, I asked everybody to sign a release form.
And Felix Fortunato did not sign his own release form.
He did not know. His wife signed for the both of them.
And you outlined the area with tape on the floor.
I did, yes, to designate the safe spaces.
And there was no physical barrier in between the event participants and the axes flying.
No, barrier's not needed.
There was no barrier.
No, there was no barrier because a barrier is not needed. The tape would suffice.
When Felix was hit by the axe, you told a fellow Cost Depot employee to go get Tommaso Machado.
I did, yes.
You did this before attending to Felix.
Everything happens very fast. I was walking over to Felix while mentioning for somebody to get Tomasa Machado.
Tommaso wrote a report about this incident.
She did, yes, as what happens when any incident occurs at Cost Depot.
You saw that report?
I saw the initial report that she filed.
Let the record reflect the plaintiffs are approaching opposing counsel with what will be marked as Plaintiff's Exhibit D. And approaching. Would Your Honors like a copy?
Yes.
Ms. Gonzalez, do you recognize this document?
I do.
And how do you recognize this document?
This is the initial incident report that Tomasa Machado showed me from the night of the incident.
Is it a fair and accurate copy of the document?
Yes.
And has it been changed or altered in any way?
Not that I can see, no.
At this point, plaintiffs move to have what will be marked as Plaintiff's Exhibit D admitted into evidence.
Your Honor, we object to a portion of this report. The portion labeled corrective measures at the bottom is additionally a subsequent remedial measure and therefore is excluded under Rule 407.
Any response to that portion?
We have no problem with that, Your Honor.
Okay, so it will be admitted with the exception of the bottom portion about corrective measures.
Ms. Gonzalez, this report lists you as an employee.
It does, yes. As I mentioned, I work at Cost Depot Deli Counter, nearly full-time.
But this report is about the incident that occurred,
It is, yes.
and it lists you as an employee.
It does, but as I mentioned, in that capacity, I was an independent contractor for my axe throwing company.
This report lists infraction or unsafe practice as the only factor that contributed to this incident.
Again, yes, that's what it says. I don't view this as being an unsafe practice as I'm adequately trained in being an axe throwing instructor.
You had been running your club for less than 2 months before the incident occurred,
That's correct. That's why I wanted to help with the event, to get it off the ground.
and you got your certificate online with no in-person training.
I did. It was a 6-hour extensive online course that's been taken by other axe throwers as well, in combination with 2-hour video of me practicing throwing axes and completion of an exam.
No further questions. Permission to publish?
Yes, thank you. Redirect?
Brief redirect, Your Honor. Ms. Gonzalez, what training did you receive to lead the axe throwing event?
Sure. As I've mentioned, I took a 6-hour-long training course, had to pass an exam in addition to submitting 2 hours worth of axe throwing practice in order to get my certificate.
Are there any legal requirements for what an individual must do to be a certified axe throwing instructor?
No, there are no legal requirements.
And Ms. Gonzalez, do you believe this space was safe?
I did, yes.
And do you believe that there was adequate space for the participants?
There was. As long as they listened to my instructions and were aware of their surroundings, there was plenty of space to hold a safe axe throwing demonstration event.
And do you believe that the 2 display tables had any impact on the
Objection, Your Honor. Leading.
I-
Grace.
Yes.
And what is your opinion on the location of the 2 display tables?
They were fine. It was just a few feet off the back, but it didn't overall have an impact on the safety of the area.
No further questions.
Thank you. Next witness.
Yes, at this time, defense calls to the stand Dr. Chris Turk. Thank you for being here. Can you start by introducing yourself for the jury?
Of course. My name is Dr. Chris Turk, and I am a cardiologist.
And what is your educational background, Dr. Turk?
I have a bachelor's in biology and chemistry, and I have a medical degree as well.
Where did you go to college?
I went to Harvard,
Where did you go to medical school?
Harvard Medical School.
And how long have you been practicing, Dr. Turk?
I've been practicing for over 20 years.
Have you published any works?
I have. I am proud to say that I published in most of the major cardiology journals. This includes Heart as well as JACC, which is a Journal of American College of Cardiology, among others as well.
Are you on any hospital committees, Dr. Turk?
I am. I practice in the New Columbia Hospital in the cardiology department.
And in what areas have you been designated an expert?
I am an expert in cardiology and more specifically cardiac arrest, or in layman's terms, heart attacks.
Dr. Turk, how do you record your qualifications?
I record all my qualifications in my CV.
Would you recognize that CV if shown it today?
I would.
Let the record show I'm opposing counsel with what has been previously marked as Defense Exhibit 4. Would you like a courtesy copy, Your Honor?
No, it's okay. Thank you, though.
Dr. Turk, is that the CV you just mentioned?
It is.
And how are you familiar with it?
I wrote it myself.
Is it a fair and accurate copy?
Yes.
And are there any assertions, deletions, or omissions in the document?
Now that I can see.
At this time, defense needs to enter into evidence what has been previously marked Defense Exhibit 4.
Any objection?
No objections.
Okay, submitted.
Permission to retrieve and publish in the jury.
That's fine.
Now, Dr. Turk, I'd like to talk about the events that led to today's proceeding. How were you familiar with the events to have sufficient facts and data to testify?
Of course. I reviewed all the statements and testimony from the other witnesses, and more importantly, I reviewed the records that Dr. House kept on Felix Fortunato to arrive at my conclusions.
And how sufficient are those records?
They're very sufficient. Focusing in on Dr. House's records, I'd say they're actually more advantageous than interviewing Felix himself because it gives me a comprehensive overall view of Felix's medical history.
And how familiar are you with Bright's disease?
I'm very familiar. I studied it extensively at Harvard.
And did you use reliable principles and methods to come to any conclusions today?
I did.
And did you reliably apply those principles and methods to the facts of the case?
Yes, I did.
Your Honor, at this time, defense would like to tender Dr. Turk as a qualified expert in cardiology.
No objection.
Okay.
Dr. Turk, talking about today's incident that is the event of today's proceeding, have you come to a conclusive finding within a reasonable degree of medical certainty as to Mr. Fortunato's death?
Yes, I have.
And what is that finding?
Being hit by the axe was not the proximate cause of Felix Fortunato's death.
And why is that, Dr. Turk?
In my professional opinion, after reviewing all the statements and testimony, Felix Fortunato was suffering from the effects of a silent heart attack before he even walked through the doors of Cost Depot.
And what makes you say that he was suffering from the effects of a silent heart attack before walking into the door?
One could plainly see that Felix Fortunato was suffering from many stressors in his life. This normally wouldn't be an issue, but with a patient with Gauss disease, they handle stress less well than a normal person. So what a normal person experiences as normal stress is compounded and impacts a person with Gauss disease more. So some of these stressors include the marriage between Desi and Felix Fortunato. One could see there were issues in that. There were also issues with Felix transitioning from his work as a full-time employee at a steakhouse, at a seafood place to a consultant, and that was affecting his income along with his interaction with Diego Cavarian.
And what objective evidence is there of these stressors already affecting Mr. Fortunato before walking into Cost Depot?
One could plainly see that he had a short temper, agitated demeanor, flux complexion, shortness of breath, and among other traits that all points to Felix Fortunato suffering from the effects of a silent heart attack.
Moving on, Dr. Turk, what does a silent heart attack look like?
Of course. So they teach you the basics of this in medical school, but to lay it out there, there's a few different types of coronary vessels within the body. Some of these major ones include your arteries, which brings blood away from the heart, veins that brings blood to the heart. When someone suffers from a heart attack, it's usually caused by a blockage to an artery, most usually the coronary artery.
And how would this case look different if the axe had been the cause of death?
If the axe had been the cause of Mr. Fortunato's death, he would have dropped dead immediately there or soon thereafter.
And what could have been done to prevent Mr. Fortunato's death?
After the review of everything, I believe that Mr. Fortunato should have gone immediately to the hospital, or better yet, he should have gone to the hospital immediately after, or gone to the hospital even before the event itself to be treated for a silent heart attack. Given his heart condition, I would not have recommended him to have gone to the accident event itself.
Thank you. No further questions, Your Honor.
Hello, Dr. Turk. You advertise your services as an expert witness in various journals, correct?
That's correct. I
Does the ABA and American Lawyer?
yes, that's correct.
And your private practice includes expert witness services.
That's correct as well.
And roughly 85% of the cases you serve as an expert witness for defendants.
Yes,
And you have been retained by Blakeman and Stein, counsel's law firm, before, correct?
the law firm, yes. These counsel, no.
And you've generated roughly between $200,000 and $300,000 working as an expert witness for Blakeman Stein.
Objection, Your Honor, more prejudicial than probative. We believe that this testimony will unfairly prejudice the jury to believing that Dr. Turk is not a qualified expert when in fact she is a renowned expert in cardiology, and the fact that she made money through the law firm before is not very probative of any material facts in the case.
The fact that Dr. Turk generated almost $300,000 working for counsel could be probative to how she conducts her expert witness services, but it's not going to be asserted to prove that she's not an expert in cardiology, as there was no objection prior.
I'll allow it. I think her bias could be relevant here.
Dr. Turk, moving on to your knowledge of Grote's disease. You revert.
I'm sorry, I don't believe I answered the last question.
You generated roughly between $200,000 and $300,000 working as an expert witness for Blakeman Stein, correct?
Yes, but that's barely a drop in the bucket at what I make at the hospital.
You reviewed Dr. House's medical reports, correct?
That's correct.
In your medical opinion, Felix should have been referred to a specialist,
Yes,
such as a cardiologist.
yes.
And that is because an expert cardiologist would have been able to prescribe different medication.
Among other reasons, and chief among them, is seeing the patient more often.
And you've treated patients for Grote's disease, correct?
I have, yes.
And you prescribed them Johnsonopin, correct?
That's correct.
And Dr. House prescribed Felix Johnsonopin.
Yes, but once again, I don't believe medication is the primary issue here.
Okay. And also, as an expert cardiologist, you would have possibly been able to send Felix for further testing.
Yes, and also see him more frequently and interact with him to get a better gauge on what his stress levels are.
And at this time, you don't know what further testing or additional testing you could have prescribed Felix.
Objection, Your Honor, speculation. Dr. Turk was not able to meet Felix Fortunato or examine him before. She doesn't know what test she would have prescribed him. That would be a very facts-based conclusion.
Dr. Turk had an opportunity to modify her deposition where she does state about further or additional testing that could have been given and her uncertainty.
I think because the question was that she doesn't know, then it seems like we wouldn't be speculating that she doesn't know. If she starts to talk about things that testing that she didn't reference in her deposition.
And so at this time, you are uncertain what additional tests you could have prescribed Felix.
Yes, if I were treating Felix, I would not know, but once again, it's the one-on-one, face-to-face meetings I find more important.
And one of your two patients with Grote's disease died, correct?
That's correct, but it's from a complication of another disease.
I'd like to now touch upon some of your other medical conclusions today. Your overall medical opinion is that Felix was having a silent heart attack before ever getting to the event.
That's correct.
Because Felix may have missed a dosage of his medication, correct?
Objection, Your Honor. Foundation not laid, lack of foundation. There was not any witness testimony drawn out on direct that was the reason for her conclusion. In fact, it was quite the opposite, that the other stressors were the cause.
I'll be getting there, Your Honor.
I think that it would be proper for counsel to probe the basis of the conclusion she already gave.
You think Felix missed a dosage of his medication because he was exhibiting signs of a silent heart attack at dinner?
That is a possibility, yes.
Such as displaying a short temper or erratic behavior.
That's correct.
And we could say that having a short temper and being irritable are fairly similar, correct?
I would not say that.
So it is your testimony today that having a short temper and being irritable or easily angered is not similar?
They're similar, but it doesn't come from the same strain.
Okay, so it is your testimony today that they are similar.
Sure,
Dr. Turk, are you familiar with the side effects of Johnsonopin?
I am indeed.
One of the side effects of Johnsonopin is irritability.
That's correct.
A toxicology report would have shown what medications were in his system.
Yes.
And a toxicology report could have shown what levels of the medication were in the system.
Yes, but I did not run a toxicology report.
In your medical opinion, Felix's silent heart attack was also caused by outside stressors.
Yes, that's correct.
And you're aware, reviewing the medical reports, that Felix had previously been through a divorce?
Yes.
And also based on his medical reports, Felix has had fluctuations in his employment.
That's correct.
And based on his medical reports, Felix did not have a silent heart attack after these stressors?
Once again, it's not those stressors independently, but compounded together. At that point, no, but at this point, I think it's a different level of stress.
So based on the medical reports, Felix did not have a silent heart attack after those stressful events?
At that point in his life, no.
Okay. And you reviewed the car accident that he had in 2009?
That's correct, yes.
And it was your medical opinion that he did not have a silent heart attack after a car accident?
That's correct.
And just to be clear, Dr. Turk, you never treated Felix?
No, but this case isn't about treating Felix, it's about the conclusion of his death.
Okay, no further questions. Thank you. Thank you, Dr. Turk.
Brief redirect, Your Honor. Dr. Turk, how sufficient were the medical records that you examined to come to your conclusion today?
They're very, like I said before, it really gives me an overall view of Felix, all of his medical history and background, and everything else that had gone on in his life.
And what was your medical conclusion as to what exactly caused the death of Felix Fortunato?
In my expert opinion, it was due to his silent heart attack and the failure to calm his heart down before he went to bed that aggravated his Grass disease.
And what could have been done to prevent this heart attack?
Well, for one, Felix could have gone to the hospital, but really he could have calmed his heart down and either meditated or taken deep breaths before bed.
Thank you. No further questions.
Thank you.
May the witness please be excused.
Yes.
Thank you.
Any further witnesses?
Defense rests their case. No further witnesses.
Your Honor, I just like to request a 2-minute recess.
That's fine.
Not very happy.
What are the exhibits?
It was 2-2 in the second. Yeah, yeah, me too.
Yeah, it's like, I like here too.
I guess that is good.
Basically sure like it's
But it is not
We made all these spaces. I'm like making this background.
looking at the judge like
Hello, judge.
it's 5 and then I'm gonna go through
Oh my gosh, hi.
right. I think
I think it's very just put.
It should be okay.
Oh yeah, I'm not worried about the word. I'm just worried about the judge. By the way,
Hey, while we're at it, I just want to do my job.
well, also like they're all
yeah.
like half of them are all
I also.
and then I'm gonna go through negligence. So negligence is an ordinary person standard.
We're selling.
If I was crossing, I was like, I don't want to do this anymore.
I don't want to go to my Thank you.
No. Only in trial. It is gonna be weird because like at this time, asking questions. But then like on Friday, it's so funny. Yeah, I know. Sit there and
Yeah.
So you're testing.
I can even stand up.
Really good friends.
Yeah.
It's not like I'm taking things to spend. Other people's
Day 0.
We need to.
Honestly,
Yeah.
Did,
There's
did
one
you
person
email
and I
it or just text it?
There's a there is.
I'm done with
I love seeing justice.
I love eating pizza or like doing some New York things.
I do not.
They said at the beginning.
because I know in like ups and
I feel like mentioning that. I'm right.
For the furniture stuff,
I can't handle it.
Rebecca, what is that? The plaintiffs have 16 minutes and 2 seconds remaining, and the defense has 23 minutes and 45 seconds remaining.
We get 23 minute long.
16 minutes.
right, shall we proceed with closing arguments?
Your Honor, ladies and gentlemen of the jury, opposing counsel has told you that Cost Depot was the wrong target today, but Felix Fortunato ended up being the target that day. Felix Fortunato was responsible enough to manage his stress, but Cost Depot wasn't responsible enough to manage their accident, or to manage their event. I want to talk a little bit about the law first in this case, give you a basis for the decision that you're about to make. First, I want to talk about the opposing counsel's defenses. They brought up a defense that Ms. Gonzalez was an independent contractor. When looking at whether or not Ms. Gonzalez was an independent contractor, the law asks you to look at whether 4 factors. I want to run down those 4 factors for you. The first is whether the action was done expressly or implicitly at the direction of the employer. Ms. Gonzalez was directed by Tommaso Machado, as you've heard today, to put on this event. Second thing that you're going to be asked to look at is whether or not this was done in the ordinary course of business. This was decided upon, and done at a time when Ms. Gonzalez was an employee of the business. She came up with this idea. She asked Tommaso Machado about this idea to throw the axe throwing event. She asked to do a favor for Tommaso Machado while she was working. And then she performed that favor at the store where she worked. The third factor to ask is whether or not there was an intent to further the interest of the employer. You heard from Ms. Gonzalez that her initial intent was to help out Tommaso Machado. She knew that the store's numbers were lagging behind. She knew that Tommaso Machado would say yes, and yes, there was some benefit to her axe throwing club. But don't be confused by that. She was doing this in order to help her employer, and you heard that today. And the fourth and final is whether or not this was done out of some impulse or emotion that would come up regularly through the course of working for the business. You heard, again, that this happened while she was at work. She saw the new displays that had axes in them from Cost Depot. And she decided that from that impulse to put on these axe throwing events. Ms. Gonzalez was not an independent contractor. She may have signed an agreement, but that is not definitive of whether or not she was. As we've shown you today, Ms. Gonzalez was acting at the store where she was a deli clerk. She was acting at the store where she worked and has worked for 4 years. She had worked there for 2 years. She was an employee on the night of July 14th, 2017. Next, the defense asks you to look at an assumption of risk, whether or not Mr. Felix Fortunato, in his unfortunate death, did assume the risk of the incident that occurred to him. But as you heard today, Mr. Felix Fortunato never signed the agreement that was handed to him. He never signed that agreement. Mr. Felix Fortunato simply went to an event, and you can see the agreement here. Mr. Felix Fortunato merely went to an event that his wife had seen advertised. It was supposed to be a fun event. There's no risk of going to a fun event. Cost Depot advertised it with a picture of a woman prepared to throw an axe at a man, joking about the safety of this event. You heard that today. You heard also that this event was put on by Cost Depot and was advertised by Cost Depot for the intent purpose of getting Cost Depot some extra money. They were grossly negligent in this case. If they were grossly negligent, you can't find that Mr. Felix Fortunato assumed the risk, because there's no need to assume risk if an event is run well and responsibly. Next, the defense asked you to look at whether or not Felix was contributorily negligent. They brought up things like he was on his phone, he was going over the line, he was stressed out about work. Sure, but he went over tape because, as you heard today, Ms. Gonzalez and her employers didn't think it was important, even though this was the third time that they had put on an axe throwing event. They didn't think it was important to put up physical barriers in between the participants and where the axes could be thrown. Even if you believe that Mr. Felix Fortunato stepped over this line, even if you think that he was there, that is still several feet away from the target. And there's no way he should have ever been allowed to be there. And that is their fault. That was their responsibility to look into and to protect the customers that came to them that day. Now, you heard a lot about stress today, and you heard a lot about how Felix was stressed. But you did hear from their own expert. You heard from Dr. Chris Turk that Felix Fortunato had a car accident in 2009 and didn't suffer a heart attack. They ask you now to believe that Mr. Felix Fortunato suffered a heart attack primarily brought on by the stress of his relationship, seeing a friend talk to his spouse, a relationship that they previously dated, but they knew about for years. They ask you to believe that a little bit of red wine was the cause of this. They ask you to believe that stress from work, even though you heard today that Mr. Fortunato's work was not as stressful as it had previously been. They ask you to believe that Mr. Felix Fortunato was contributorily negligent because of all of that. Now, when looking at that, you have to ask whether or not an ordinary person would have acted in a similar manner. Would an ordinary person, even one with Grote's disease, have gotten a little bit upset that his spouse was talking to an ex? Maybe. But for a few minutes, just as you heard today from Mrs. Felix Fortunato, or Mrs. Desi Fortunato rather, that he got upset for a few minutes. It wasn't that big of a deal. Would an ordinary person have maybe been on their phone at the event? I think we can all agree that we're on our phones too much, especially if you know something's coming up for work. If you run your own business and you know that you have to respond, yeah, he had a deadline coming up, so he was on his phone. That seems perfectly reasonable. Seems like an ordinary person would do that to me. Now, we asked you today to find whether or not Cost Depot was negligent for the actions that they took and negligent in Mr. Felix Fortunato's death. Again, you have to ask whether or not an ordinary person would have acted in a similar way. Would an ordinary company have let somebody who had only been done axe throwing demonstrations for 2 months be at that event? Would an ordinary company have taken away space and then further told that unqualified individual that they couldn't have the extra space that they requested because of the display tables? Does that seem responsible to you? Would an ordinary company have advertised for an event, seen that over 50 people on that one platform, which they didn't advertise for their other 2 events, would they have decided that they didn't need to prepare for any more people to attend than had previously? No. We ask you to find today that the answer to those questions is no. We ask you to find that Cost Depot was responsible and acted negligently in the death of Mr. Felix Fortunato. Mr. Felix Fortunato knew how to handle his stress. He could handle it responsibly. You heard that from Dr. House today, his physician of over 20 years. Mr. Felix Fortunato got through a previous car accident. He got through a divorce. He got through working 16-hour days at Joe's. But he didn't get through attending an axe-throwing event at Cost Depot because Cost Depot wasn't responsible.
Your Honor, members of the jury, untimely deaths such as this are tragic to everyone involved. However, it won't bring Mr. Fortunato justice to hold the wrong person responsible. And Cost Depot is simply the wrong target to aim at. Today, the plaintiffs have the burden to prove to you by a preponderance of the evidence that Cost Depot was negligent and that negligence proximately caused Mr. Fortunato's death. They have not proved this to you today. They offer no proof that a reasonable person would have acted any more carefully in this situation than Cost Depot. You heard from Ms. Jamie Gonzalez of her adequate training to be an axe throwing instructor and of her proper presentation and excellent instruction to the participants on the day of the incident. You heard that she provided proper oversight to the participants during the axe throwing event, and in fact saw Felix and some others crossing over the line where she had marked off for them not to be, and so she yelled, "Hold it." Felix was not supposed to be on that line, and Jamie saw this. She was overseeing the event, and she tried to get Felix and the others away from that unsafe area. Cost Depot exercised ordinary care in preparing the space, preparing the presentation, and instructing the participants, overseeing the event, and attempting to provide medical services to Mr. Fortunato after he was hit by the axe, even when he resisted. This was a judgment call by Mr. Fortunato not to go to the hospital and not to seek emergency medical services. Cost Depot could not have intelligently made this decision because they were not aware of Mr. Fortunato's previous existing condition, his gross disease. And they did not see him at home that night where his condition deteriorated. Yet the Fortunatos saw this. They saw his condition worsen and still chose not to go to the hospital. In fact, the evidence today paints a completely different story than the one plaintiffs tried to tell you. You heard Desi Fortunato tell you that Felix was having a work deadline come up after the event, and that they had had talks and conversations about his increasing workload and their relationship, about needing to spend more time together. Felix had recently taken a pay cut to go to this new job, and he also had the stress of that pay decrease on his mind. He had many stressors that night, including the fact that Desi testified that she invited her ex-boyfriends to the event as well. And then Felix saw Desi and Diego leaning into each other and was put off or upset after that incident. You also heard Dr. House testify that Felix knew how to manage his stress. Yet he doesn't testify that Felix knew how to manage these new stressors and hadn't even seen him for 4 months, where Felix's stress levels could have very much fluctuated in that time. If Dr. House had recommended Felix to a specialist, a cardiologist, perhaps the cardiologist could have seen Felix sooner than 4 months. You also heard Jamie say that she heard Felix and Desi bickering to each other that night at the event. For Jamie to lead a group of 36 people and notice 2 people in the crowd, then Felix and Desi must have been pretty angry at each other. Dr. Turk tells you that these other stressors were the true cause of Mr. Fortunato's heart attack. You heard that Mr. Fortunato was experiencing objective symptoms of the silent heart attack before walking into Cost Depot that night. His sweatiness, his flushed complexion, and his agitated demeanor I'll show the truth. Plaintiff has not met their burden today and has not proven their case. They have not shown that any acts of Cost Depot were negligent and that these negligent acts proximately caused Felix's death. However, even if you find that plaintiff does meet their burden by a preponderance of the evidence to prove this to you, then if you find that even one of our affirmative defenses is more likely than not, then you must find in favor of Cost Depot. This was the only option. We proved to you today 3 affirmative defenses, more likely than not. First, Jamie was an independent contractor, and therefore Cost Depot is not liable for any of Jamie's actions. You saw that Jamie signs an independent contractor agreement in her capacity as the owner of Bury the Hatchet. She was not acting in her capacity as a deli counter employee of Cost Depot. Now, plaintiff tries to tell you that because Ms. Machado exercised some direction over Jamie and that they were not acting within a normal, ordinary course of business, then she was not an independent contractor, but this is simply not true. Cost Depot can still exercise and direct independent contractors to do as they say. Independent contractors are still agents of Cost Depot. Cost Depot can still direct them to do certain things. And this was not in the ordinary course of business. This was a one-time event and a special demonstration, advertisement for the Axis. This was not a regular event that Cost Depot put on or that Ms. Gonzalez ever led. Ms. Gonzalez was acting in her capacity as the owner of Bury the Hatchet, not as the manager of a deli counter. Cost Depot would not let a deli counter employee lead a demonstration of axe throwing. This was completely separate. Second, Felix Fortunato contributed to his own death. Felix knew the risks associated with Broad's disease and the risks of drinking wine while on Johnsonopin. He knew that he was stressed and still chose to go to the axe throwing event. And as the plaintiffs say, Felix and Desi saw that the axe throwing event was a bit crowded, and yet they still chose to stay and continue with the event. Furthermore, Felix and Desi chose not to go to the hospital after Felix was struck by the axe. This was negligence. An ordinary person, a reasonable person, would have gone to the hospital, especially when Felix and Desi got home that night and Felix was sweaty and pale and agitated and his pulse was racing. An ordinary person would have sought emergency medical services in those circumstances. Now, lastly, Felix assumed the risk for any injury that may have occurred at Cost Depot that night. You saw that Desi signs the release agreement for Felix and herself. She signs in both their names, waiving Cost Depot of any liability. And further, as I mentioned, they chose to stay at the event and continue with the axe throwing after they watched the presentation and after they saw how many people were there. This means that they assumed the risk for being there that night. Plaintiffs have not proven their case today by a preponderance of the evidence. They cannot point to any lack of preparation that Cost Depot may have undertaken. Jamie was prepared for 30 participants to come, and 36 came. Obviously, this must have been a pretty good estimate of the number of attendees. We all know how we get excited about a Facebook event and click that we're going when we actually have no intention of ever showing up to that event. 30 people was prepared for and 36 came. 6 people is not enough of a difference to make Cost Depot negligent. In fact, they exercised ordinary care in every aspect of preparing and executing the axe throwing event. The plaintiffs have not proven their case today. However, even if more likely than not, then you must find in favor of Costipo. Because Costipo is not responsible for this event. Costipo is simply the wrong target to aim at.
Any rebuttal?
Yes, sir. Felix Fortunato didn't go to the hospital that night. I'm sure Mrs. Desi Fortunato regrets that very much. But he had 20 plus years of experience dealing with this disease. He had been in a car accident before, and as you heard from Mrs. Fortunato, he had dealt with stress well in the past. His own doctor, who had been treating him for 20 years, heard exactly from Felix that night the symptoms that were occurring to him and decided that it made sense. A medical expert says it made sense for Felix to not go to the hospital that night. Now, Costipo says that we're aiming at the wrong target. The target they want you to aim at is Mrs. Desi Fortunato. We ask that you not do that today.
Thank you. Got it.
I get anybody anything?
Will you go to the unisex one?
What?
Bad form.
Almost 2 hours.
That's scooped.
Hurry up, 15 almost, right?
Do you want to throw it away together?
Sometimes they do this several times.
Imaginary I thought you meant like keep it. I was gonna be like,
I get really crazy. You crazy person. Okay. You okay? It's always a little nerve-wracking. Yeah.
No, yours are good.
You still.
Yeah, right. It's like a
You sat down and
So do you?
Wait, why did we do
every year you do like one day.
You know,
So much.
the best part was
So what do you?
in honor of women.
Very good.
Honestly, if you just like opened a tab for me, whatever
I'm still. Okay.
instead of food, would you like me
do you guys give 2 more minutes? What?
I recommend water and Sprite.
I made it back.
That's relaxed.
Yeah.
We did
too long.
What else should we pick?
I might make an agenda.
Please do.
Yeah.
Oh, yes.
I got pictures. I'm Cohen.
When you care
We call it holiday food night. Oh, yeah.
No, my
Yeah,
problem is
I was like a non-denominational.
Nate, well, that's Keith, I was right.
It's too suspicious.
Yeah, no, this is like walk out.
Okay.
So,
Kristen might be the first
because she would appreciate going well with it.
Probably for this, I'm like,
I think it's more.
We already have my cookies, actually. They're gonna be here after the event.
He brought some for you. Okay. He's already excited. Oreo at least. Sure.
I'm glad you didn't have to go at night. Is that why I had to leave at night?
Oh, you guys did one day.
Celebrate.
Hands up.
That's so sweet of you.
Yo, Mitch.
I show up at every event.
Yeah, no, it is. Do I just want to say that I don't even know right now. I'm like, I don't know what people know about
It was not a phenomenon.
Oh, disaster. That's true.
My pick, yeah.
Wait a second.
Was that?
You're a big boy now.
I was thinking everything in front of people.
That was not nice.
I thought planning is so
Basically, that's really my bunch of people waiting. I always buy an
It's
extra
just
of
in case, it's not an
everything.
accident. I'm with you, I really want to go to Blindfold. But also, if it was your mom, she would kill me.
Also, like, this would make me sick. Like,
Better be
and then the witnesses started looking for the judges.
Of course you did it.
I think it's the only option. We have to get home before
It's literally way too high.
You're big.
no idea. I didn't want to say anything on Sunday because I was like, stressed. I was like, 11.
I know.
Or food or whatever.
Big time. Absolutely. Let's go to town. Yeah. I want the pocket square.
I'm still nauseous. No, I agree with him, by the way.
Oh, the second part is different colors. This one's
Or emotionally broken. Nothing you can do. This one goes up to 11. This one goes up to 11. Top out of 4. This is perfect.
No. Oh my god. My mom's good deal.
Also, Bear the Hatches is a real accident.
They did not care.
Because my hand when I was doing it, to close it and quickly help it.
What if you guys are all Grab it. See, I'm having a hard time sentencing
I should not have been a surgeon and chose the right profession. Yeah. Resting. This was the best decision today.
This was to be friends with her. Look, to ever succeed.
The group cannot compete.
I like don't understand where people go.
Whatever this one.
Oh, you want to do Ben Black?
No,
I suck at writing groups. It's very
What would be fun? Like throw some plates.
you can.
Anybody can do it. All it takes is 6 hours.
All you need is get up there for a text.
All you need is get up there and speak loud.
More time than that.
That takes very long.
Yeah, actually,
The last page for like literally just one of them because
I haven't had any good days today, so it's I tried to eat and it did not work now. I was like,
That's what I think.
So that's like, you know, it's probably
this is the nice pile of plates I'm gonna chuck in the trash.
yeah.
Yeah.
Oh,
The deposition.
I mean, maybe
Oh, that's
interesting.
smart.
See, I just have mine in the binder.
I don't know, it's his idea.
If we can just present one deposition at a time. Do that. I'm doing more as we do it.
Yeah, but honestly, when you get this far, like you'll probably never impeach a witness because they're like so correct.
Yeah. Yeah, that's true.
Well,
Only one, two, three.
cases that you're looking at.
That's what I'm saying.
Impeaching, I mean, yeah, deposition, if you have the money to do deposition. Unless it's like a professional witness, you can't rely on them.
Oh, yeah.
Oh yeah, in real life. Yeah, I can imagine.
Yeah.
Yeah, I don't know why. And I turned it like for no reason. Yeah, for no reason. It was just like,
And they back off. Yeah.
I was like, oh look,
Also, they know we're gonna like lie. So like if we're saying that, I feel like if I were a witness, like I'm a witness for arbitration, and they would say that, I was like, yeah, okay, they know the facts. I'm like, I almost want this one.
Yeah, that's true. Like they've written about it.
Yeah.
So we could, well, I guess.
are we painting and carving or just?
Just painting.
Literally perfect timing.
I know. Why am I still like residually anxious? When's it gonna go away?
Eating generally helps with that.
I'm gonna take the time.
Your body doesn't like being
You want a yogurt?
This is also contingent on lactose intolerance.
Yeah.
You want a yogurt?
She's got ordering slots.
100%.
Orange slices. What's the orange?
Nobody.
I love orange slices.
Yeah, right?
They help with my nausea.
This is the Jacqueline didn't we should have done.
I'll help.
You know, true American. Story.
He doesn't love mine.
Advertisement.
Oh my god, they're so cute.
That was just.
It's chocolate. I don't actually know if chocolate. Yeah. There's a chocolate food truck right outside. That's where you see this is like.
Think about eating.
Everyone's so disappointed.
What if we got you?
We're hungry.
Yeah, right. Think about us, Maddie. It's about us. This experience is about us. We're living our life.
Yeah, he's so my god.
Where did
Okay, we might go to sleep. They're like 10 minutes on the crafts. Could be worse. Oh my god.
Yeah, hey, click this.
And all I can say is, you know.
I got this.
Okay.
That's all.
And I rest my case. Oh, you, yeah, that's right. I like these. I like those. I think those bees make things.
No, I know.
Those bees make things. I like that. How I was helping. That's nice. Yeah.
I feel like that could be.
Because if it's 20 minutes away, 20 minutes
Oh my god. The fact that you're wearing that suit. Yeah.
Exactly how like a doctor should do
You know what else I think is hilarious? I also think that if you look like one of these people is like one of these
Party women.
like 100%, like just the way they're doing, like all blacked out suit. That's the corporation. The kind of. Who did that?
Do you know, Kissy, you're a.
Yeah, we're good.
Oh, okay, all right.
Okay.
Okay, I'm sorry, I thought we were going with this. All right, so we can do feedback then.
Okay. And Dean Johnson's going to jump in. So great job, guys. I'm going to try to give helpful, specific feedback so that you can take that into your next competition and your future law careers. And so I'll try to not talk too much about general strategy, but we'll just kind of start from the beginning and work through the trial. I think that'll be the easiest way to do it. So with regard to decorum, no one had an issue with decorum. Everyone knew kind of procedurally how to interact with each other and with the witnesses. So all wonderful on that. With the motions in limine, I thought that everyone had good initial points. I think where there was more space was the response to some of the objections. I don't know if we always anticipated what the issue might have been. And so there was a point where I was asking, well, are you conceding that point, or is that something that you're going to be arguing? And I think that is where in motions of limine, I think sometimes you see where people are adapting. I think that's where teams can shine, is when they show how responsive they are to the positions taken and saying, well, this actually isn't an issue at all, Your Honor, because we're not going to be offering it in that way, or we're not contesting this position. Let me look at my notes again to be a little bit more specific. I heard use in one argument of case law, and that's always great if you have it and can use it. I think Jessica was the one who cited a specific case. Sometimes the particular argument you're making is a more straightforward argument, or it's very grounded, but it's always good to be referencing the rule. I think everyone seemed to have a pretty good grasp of the federal rules of evidence, but I didn't hear the numbers called out very often. And I think especially in a motion to eliminate, that's where we're looking for it. That's where we are kind of seeing the most obvious explanation of your kind of grasp of the law and why this shouldn't be appropriate. And let me go back. Sorry, I lost my. Also, great job of kind of remembering what the rulings were. So with the first motion to eliminate about the relationship, I kind of didn't really make a ruling and said I would wait, and then you remembered to make the objection and to re-raise it, and that's also important. I think judges are looking to see if you are going to keep track of kind of how the case is shaping, and always still, if you have an in and a way to try to reiterate your position, take it. And so Matilda did a good job with that. I don't have any other, as far as motion to eliminate, I don't have any other points on that.
So I don't have anything to add on motions to eliminate. I will say just sort of one thing, cosmically, it was really gratifying to sort of watch the final round, because this is actually, I really wasn't sure I'd be able to judge today because I judged the prelims, so I can't judge anybody there. And then Brooke, who's in the competition, is my RA. and Sydney's volunteered to do a lot of public interest stuff. So the fact that you two made it, it was like, wow, I can actually, judge this. So you're actually the third round that I've seen, and what was really great about it was there were, and I said it in my feedback on Saturday, there were flaws, real flaws that the teams I previously saw could correct, and you guys were you clearly belonged in the finals. I mean, you were so much, so I really do mean that. I mean, I think that this gentleman here is the best team I saw, but his big flaw was they read a lot. I mean, they really did. But they were in many ways as good as you guys, but boy, did they read a lot, and so that was a big flaw. And you guys just sort of didn't. You didn't really seem like. I hope you all took trial ad, and this isn't just from your soul. But if it is from your soul, you got a lot of talent. So it was very impressive to see this level after having seen student level on Saturday. A good student level, but student level. So.
Yeah, nobody was using notes. Everyone had a really good grasp of their facts, and that was so persuasive to kind of listen and watch, and really fun to watch you guys do that. So. Really
and you were the best team I saw on Saturday, by the way.
So openings.
Openings. Here's what I'll say. So when I score these things, I actually treat. I don't know if you're supposed to or not. It's just what I do. There's a lot of freedom being judge. I treat the openings and the closings together. And so what I saw were actually 3 that were very similar and 1 that to me stood out a little bit. And the 3 that were similar didn't use any notes. God bless you. But I also thought that those 3 suffered a little bit from a lack of emotion. This isn't a mock trial. Sorry, this isn't a moot court. This is a mock trial. And although we're doing a moot court all weekend, yay. But it's a mock trial, and a person's dead, and whether you were defending the person who's dead or whether you're trying to back off from, we didn't kill the guy. I just think there is room more for emotion, it's interesting, the person of the 4 of you, and again, everybody was the person that to me sort of stood out, and I wrote on various things, this is your best moment, and I wrote it, I really thought, Dan, you're closing, and it's interesting, I don't know a lot about baseball, but I'm watching it now because the Knicks are in the World Series, and they always, from what I'm learning, you got to get on good pitchers early. And you started the slowest of any of them. You had your notes and you were kind of wedded to them. And compared to them, that's utterly unimpressive. But then you were walking over and pointing. No, but this is good. You were walking over and pointing at things. And you actually showed some emotion and you brought it back down. And it felt to me more like a real trial. So it took you longer to connect, but then when you did connect, I really thought you were on. And you were doing again what you weren't just a sort of, you broke out of the prefabricated, really well done things. So I thought you're closing, but the rest, all I can say to the rest of you, incredibly well done. Just you're dealing with real people here. It's not a mock trial, and again, to use some of his witness on the stand broke down and cried, and so you're dealing and did it very, very effectively, so you are dealing with real people here. And I would encourage you to sort of find whatever that emotion is, and also to move about the well and keep everybody's attention.
So with the openings, I completely 100% agree with what Dean Johnson said about emotion, and that's always the case in these kind of fact patterns, right? There's always the emotion in the air, and you guys have it on your side, and so I especially expect to hear kind of that sob story, right? And I think you did a good job of eliciting that in the examinations. But I wanted to see more in the opening as far as the story. Talking, and here the facts really allow you to get more into telling a story about Felix, because it kind of goes to his stress management, his day-to-day, and so you have, I think, more leeway than in some cases to talk more about the person who's no longer with us and the impact of that. And that helps you because in some ways you have kind of an uphill battle from a proof standpoint. And so the more time you're talking about the story, the more time that you're painting a picture, and kind of looping that into your burden, I think the more persuasive. And I kind of forget that, oh, you guys have a kind of hard row to hoe a little bit, because I'm so entrenched in the story of who was affected and what I'm going to hear more about. Especially because you guys have so much as far as the history of management. So you really can kind of be giving that to us on the front end, not just from you're going to hear from this doctor who will say it, but you can you can give a story about that, right? And that's a way to kind of humanize the person who is lost. It's a way to also make what the plaintiff did or what Mr. Fortunato did seem completely reasonable, because you're telling it in a story as just something that one goes about doing. It's a hard disease, but he manages it and he makes sure that he does his meditation, he does this, he does that. And you can choose to even talk in a certain tense or be active in the way you do it so that it seems more human, right? So it's not just we're presenting a case, but this is a story about a person, a real person who is doing his best and should be here today, but for the actions of the defendant. And so I think that there's also a lot of space to do that on the defense side too, with painting a picture. You guys had a clearer theme. It was about, the target. I kind of winced almost, but it.
Okay, so I'm gonna chime in here. So my mom and I are very different people. Like, we literally could not be more different. But whenever I do a thing like this, I always try to think, okay, fine, I like something, but how would my mom react? My mom would hate that reference. Like, a guy died, and they're saying because he was in a target zone, and I so agree with the wince thing.
Yeah.
I think I got the theme, and it's maybe too cute by one. Maria Johnson is gonna hate you. So you've lost her vote. So.
And I think sometimes it's like, it's hard, it's kind of right there and it seems perfect, it fits. And so it might be good to run it by other people who are not involved in the case, and ask them if it sounds a little too kind of like, you're kind of trying to beat up the victim, but you're not. You don't want to look like you're beating up the victim. And so sometimes I think there was a part of what you did at the very beginning, when you said something to the effect of, justice isn't going to be found for Mr. Fortunato by blaming the wrong person. Like, what happened was very tragic. And so sometimes your theme is not one that's so based in the facts. It's more like acknowledging, like, this person's not here anymore. And we can't, this isn't going to bring him back. Like, this is two wrongs don't make a right, or what, not to use that's overused, but something that might not be so fact specific, that acknowledges kind of the fact that someone is gone and gives you credibility and makes you seem like the reasonable party that's arguing, but is also saying, but getting it wrong here is not going to make that right? That's not justice. That's not what justice looks like, or whatever.
That's what I meant by I think for them it's more justice.
Right.
But I meant more from the heart.
Right. Similarly, I think you want to paint a picture, and so I think. Actually, there was a moment on the on the plaintiff's side, where you were kind of getting there as far as it was a hot night and everyone was sweaty, and I could almost see like the kind of mess of like trying to get through and trying to get a picture of his wife doing the axe throw, right? Maybe we act that out, or maybe we at least use some movement to be like, I'm here now and I'm talking about what's happening, and then I'm moving away because I'm talking about a more sobering issue about who's responsible, who's to blame. And you guys.
This may not be him. I'm just picking up just sitting there. But I remember in one trial, they just kept demonstrating the throw, 1, 2, 3 throw, and it was impactful to sort of see that. So.
Right, and I think that you guys can do that because, so you have the hard part of saying, number one, they can't prove negligence. But also, look at all these other balls in the air that are affirmative defenses. And I think it's difficult because you're trying to argue both points, both sides. But you can do that through telling the story of what's going on, right? So, and there's so many things going on, and what doesn't Cost Depot know? They don't know anything about Mr. Grote's condition. And then you go into a space where you're talking about that, right? They don't know anything about, the training that this person has, and you're going to hear that they'd been doing this for 2 months and that they never kind of prepared for anything like that. Like, you can kind of use space and painting a picture about the affirmative defenses without making it seem so like legal, because I think that that is when it kind of gets a little bit boring, even though you want to kind of cue up for the jury. These things are out there. We want you to consider them, even though at the end of the day, they can't prove negligence.
And that goes back to what I was, again, Lauren is saying it better than me, but what I was trying to say with the emotion, when the other three of you sort of stood still and you moved around, you were just less boring. You know, you were more, you know, I heard more of every word, you know, you said, which is, you know, we got to hear you.
Right. And just also with so I was a defense attorney. I've never been a civil litigator, and I've only litigated in civil cases that were connected to criminal cases. But where you don't have the burden, but you do have an affirmative defense, you want to be careful about your promising. And so I think that in opening, you're more phrasing it as, you're going to hear about the other factors that were at play here that are independently affirmative defenses, right? So you're kind of framing it in this kind of more amorphous ball where they're just going to hear these things that make it more muddy, like, oh, well, that seems weird. Like, who really is the employee? That's not so clear. Oh, well, he signed a contract saying he assumed the risks. You know, that's not so clear. So maybe if you're going to, you also don't have to choose to go after all of those things, right? But if you're choosing to, I would try to frame it in a way that you're not promising to prove all three, because maybe that's not what comes out, right? And you really want it to be about a lack of negligence, because that's the burden that they have to prove.
No, I do want to say, Madison, to me, the first sort of like, and this is very trivial, but the first great moment of the competition was you were utterly unflappable when the agent walks in the middle. Andrew, you're a wonderful man, but, you know, and by the way, that happens in real trials. But I mean, see, again, I'm the old guy. I've been here 18 and a half years. I deal with students more. I haven't been in court in about 20 years. I mean, really, you know, in court. But so many students just melt down at that moment, and you just kept going, which is great. So to me, it was the first sort of like yes moment, because I really thought, oh God, this is going nowhere good, and you handled it perfectly. So excellent. And that will happen in a real case. That will absolutely happen in a real case.
Okay, so then we have the direct. So Daniel had the first direct. Everybody had great tone on direct. In my opinion, direct can be very difficult sometimes, difficult from a scoring standpoint, because everyone's looking for the cross, right? And the leading question. And so direct, I think you actually have to work harder sometimes to tell a story in a way where you are letting the witness shine, but you're also showing some mastery. And I think that there's space to do that with headlines. All of you guys should be using headlines when you're going from one area of your examination to another. And direct is especially the place to do it, so we kind of see why this matters. Sometimes it can even be setting up an objection to relevance, right? Now I want to talk to you about why it is that you chose not to go to the hospital that day, right? Well, when you get an objection in that line of questioning, you kind of already primed me to think this is automatically relevant. So use headlines to frame your questions, especially in direct, but also in cross. And you went chronologically after you started with kind of the zinger of why are you here today? Oh, my husband's dead. I'm so sad, which is great. I like that. See if there's a way to, on the back end, if any human, you know, our expert witness versus our kind of human fact witness, to also allow that at the end, right? You start strong and you end strong. And if you're able to end with the deceased wife's sob story at the end and kind of make it really uncomfortable for opposing counsel, that's a good way to end. So think about that when you're framing the questions that you ask. We had some objections that you know are coming, right? So you're trying to get through this lady, basically habit and character evidence, right? You're trying to get out that he always knows how to handle his stress and he never has a problem and this is what he does, and that's why you know that but for this axe throwing incident, he would be alive now. And so you have to be really ready for those objections. I think that there were some completely appropriate objections and some that were missed that were going to the heart of that part of the testimony. And I think you want to be like, it takes nothing. It takes just you spit it out, because I think sometimes we had to ask more, or it was on the second bounce back to you that you were saying why it was relevant, but you start on the front end. This is relevant. It goes to causation, or a critical part of this case is the issue of how Mr. Fortunato managed his stress. And the testimony here does blah. Saying fervently something is highly relevant does not make it so. And so just know, like, why. I'm always going to be thinking why, and so put that into, and this is not just for Daniel, this is across the board, but I think Daniel was getting those because his witness was like required to kind of fill in most of the case, and so you have to be ready for that.
I'm going to chime in on two things here because she touched on them. Well, one she has it, but it was just direct in general. Daniel, I wrote, and then the other side did their thing. You know, a large demonstrative would have helped. You know, she had this little piece of paper, and there wouldn't be anything because you were the guy who seemed to be able to, you know, break out of a roll and move around the room. You know, you had a pad right there. I mean, she could have drawn, you know, the thing. So then turning to Madison, you know, well done. You know, 3 trials. Finally, somebody had a pre-printed demonstrative. It was excellent. I gave you an awesome double underline, but you made one mistake with it. You left it up. When you're done, take it down, because Deanna or whoever, maybe it was Matilda as well, but they were effective using it up there afterwards. That is your toy, okay? You paid for it, you bought it, it worked really well for you, and when you're done, you take that down. And somebody else, I don't remember which side anymore, I don't remember, but a witness, one of the witnesses was sitting here with a 13-page document, you know, in her lap. That has to go. You know, she kept looking at it, answering questions. No, you got it into evidence, and the other side needs to get that away from her. This is her testimony. This isn't her just basically reading a document. No. So, you know, when you get something good, take it away. I mean, once you put it up, it stayed up all trial. Now you could put it back up for closings. You want to use it, or for later, but don't let them you use it at all. But that was fantastic you did that. I'll throw it back to you.
Oh, this is another point that came up with the objections for everybody. Not just why it's relevant, but how you're going to prove it. Because, like, maybe the person hasn't finished their statement, but you know what's coming. You know why you asked it. And so sometimes we were getting proper questions about foundation that if you kind of in your answer explained the witness is going to testify, blah, 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 and that lays the foundation, you kind of shut it down very quickly. And just remember that the person being unavailable, the dead person being unavailable in and of itself, I think that was your, like, go back to, like, well, we're not going to hear from him. And it's like, you're right. But, and sometimes you have it, right? So eventually I think you did get to, you know, this is why it's being offered. It's not for that. But think about kind of, I think when you're mapping out your questions, for every question you want to have, like, what's my objection response, or what am I trying, what can I say that passes the laugh test, right? So that you're not having to fall back on, well, they're dead.
And just to keep with the baseball references, I actually keep track of every objection. I've just scored for so long, and just as a statement, you guys did not make enough objections. I believe you might have made only 1 or 2, and you made a lot more. You made them work for it, which was fantastic, and you also won more than them. So to me, one of the big differences in the trial was you guys are just about as good as an objection team as I've ever seen. You know, at a student level, okay, but you made them work and you won a lot. One thing I can tell you both, though, that you could do better, you know, you had the head on the swivel witnesses who kept looking at you and looking, you know, I don't care what they teach you in mock trial or what you get in a info session or tip session. You were told to stand there because that's the right place to stand. Okay, fine, great. But not when they're doing the head thing. Every courtroom is different. So to get the effect they tried to teach you there, you stand over there. Okay, so then you're not in the story, which is the whole point of a well, for cross you want to be the center of attention, but for a direct you don't want to be. But get over there, because this head thing is crazy, and you had to see that while you're doing it. I mean, doing this all the time, it's distracting from the story or the facts you're trying to get out. So just because some class told you to stand there, they're not telling you to stand there. They're telling you don't make yourself the center of attention when you are the direct. You are typically told to stand at the podium when it's cross, because it is all about you. So I guess even the class thing, we could say one of you was wrong at cross. but you got to be over there because you want this more natural conversation to come this way.
And just a few points on cross, because I think we've already talked about objections. The objecting to the demonstrative, I think that's not going to go anywhere. That's like, you guys can always argue, of course, about her perception and her memory about where people are, but people can always come in and say, this is a map or this is a diagram, I was there. And it's not hearsay if you've said that previously because you are using a demonstrative. So I would just scrap those kind of objections. And also when you are arguing, and you're right, you don't have to say, I think this is relevant or I think that this is probative, just say it's probative. I think there was a point where you were arguing correctly that how much a doctor was getting paid is probative. And you're like, it could be probative. It's like, no, it's probative because you think it's probative, and so say it that way. And then it's completely fine to make the objection, but it's probative because it goes to bias, right? Like, I'm paid for my testimony. The jury should be allowed to consider that. Okay, so I'm gonna move on to the next part, the next witness.
And I'm of course the one who's all over the place.
I'm going back and forth too.
Yeah.
So, okay, we had the doctor, Dr. House, I wanna say?
Yeah.
Okay, Dr. House, and that was your direct. And everybody will kind of dabble on both sides as well. Everyone who had the experts did, that was no problem. You guys knew that I need to go into the background, talk about what you've done before. Have you been qualified as an expert before? I'm trying to remember who it was. I think it was Dr. Turk who had the problems with the disciplinary. Is that right? No. Oh, Dr. House. Dr. House had the problems with disciplinary stuff.
Dr. Turk went to Harvard.
Oh, right. Yes, Harvard fixed everything. Okay, so Dr. House had the disciplinary issues, and you brought this thing out on the front end. And I understand that, except for I think a really reasonable rebuttal would have cleared it up properly as well, because those disciplinary things were not found to be sustained against her. And so I think that so that your witness doesn't look shady, I wouldn't ask about all those specific details about the disciplinary hearings, because a very easy rebuttal is, Doctor, you were asked about disciplinary accusations that were made against you. What was the outcome of that accusation? Oh, I was found to have been completely in line. Were there any repercussions for you? No, I continue to be a great doctor and make all the money and do all the things, right? So I think that is a very cleanly handled rebuttal. And so you want to be able to think about, like, do I want to kind of lose momentum or kind of make this thing seem like it's worth more weight than most people might think it is? Because I think you have a very clean explanation that the doctor wouldn't look shady. It's not like something was sustained a long time ago and she has to explain it. She was found to be not culpable in that. I think everyone did a great job of getting out like why the expert was qualified. I liked the objection about the grouse disease. Of course, I still allowed it, but I think it was good. You want to be ready for that, and you were. You're like, it's a rare disease, so it's not dispositive that she's only treated the one patient. I think when you're going through the organization, for both of you, you guys sometimes started with the conclusion and worked backwards. Like, both of your experts started with their conclusion and worked backwards. I think it's more helpful for the jury and for the judge to start with a little bit more about, like, tell us about grouse disease. What is it? Before saying, what's your conclusion about what happened, and then going backwards into grouse disease or why grouse disease can cause it or whatever.
And, on that point, this is incredibly small. I'm going to say this is bigger. These witnesses, they don't know you, and each time you get up, you should introduce yourself to them. They have absolutely no clue who you are. Just generally talking about cross-examination, that was your finest moment. You were absolutely spectacular at your cross. I mean, just a couple things that I wrote here. You actually got her to admit something that she said no to. They didn't object to asked and answered, and you asked it again, and she admitted it. You also, give me one second here. You got her to stop looking at the bench. Clearly she had been trained to do that, but she got so fixated on you, she just sort of lasered it on you, which therefore made the cross about you. So that was great. I think she began to you kind of got a hold of her at the $300,000 thing. yeah, you got her to admit something else she'd previously denied. But that was just really, really well done. And then Dan, sort of on the opposite side, you were good, but you had Chatty Cathy as a witness,
Yeah.
and you have to keep asking her, that's a yes, because she was going to give you a speech, but you needed to bang home your yes, because she would have said yes if you kept doing that. But and also she gets exhausted at some point, and she begins to not do this thing. But you were making your points, but we had to really pay attention. I think if you, at the end of her speech, said that's a yes, I mean, again and again and again, I think the jury begins to get tired of her too. You know, she's trying to tell a story that's actually, you know, a bunch of smoke and mirrors. There's all these problems with it, and he's taking us right through it. You know, so you need to gain control a little more the way your partner really got a hold of Harvard. So.
And I think with Dr. House, so with Dr. House, I thought that Madison, you did a great job as far as your organization of starting with the disciplinary, starting strong. That was good. She looked shady. And I wanted you to make more of the alcohol note. Nobody was impeaching anyone with documents, and sometimes you make that choice strategically, but I think here, when I looked at the actual note, what she said in the note was much better than you've talked to your client about the dangers of alcohol. Because in the note, she's like, you know, he told me he drank alcohol, and that was concerning to me. I reminded him about how dangerous it was. And sometimes using the language, right? So, and in fact, this isn't the first time that you've discussed alcohol and its possible dangers with the client. And then go into it and hold up the document, and you don't have to read it because maybe you already know exactly what it says, but be precise. It makes it seem more weighty. And then I should care more about the alcohol. I think that you could do more with it in that way. Everybody had at least, especially whoever had the Jamie, like some impeachment with the document of the specific word and phrase that was made needed to happen, because it seemed like things were allowed to be imprecise, and the imprecise version was always going to be better for the witness. And so I think that's a way to demonstrate control, but also to signal to the fact finder, this matters. And I think that there were some opportunities for that with Dr. House and with Jamie especially. With Dr. House, you want to watch for, I have written down, there was a lot of testimony about her knowledge as if she was a fact witness when she's testifying as an expert, but she can't speak to, and I think Peter Cross was forced on that. You know, she can't speak to what he did day to day. She can't speak to what he did for the last 4 months even. And so there are completely appropriate objections that can be made when she's making those kind of statements. The other thing is, there were a couple times where we weren't leading. It was like, is it possible that this could happen? Is it recommended that a person use alcohol while taking this medication? And we're leading, right? And so that's a whole chapter about what, you know, you're making sure that your client is taken care of, and you want to make sure that they're doing everything they can. And so you made sure to tell him about the dangers of alcohol. You made sure to tell him about how important it was to manage his stress and take time on that. Like, you guys had, not that you need to go over, but I think there was time to develop the chapters a little bit longer and paint a picture. With the other, I'm trying to remember who asked this question. Oh gosh. Someone asked a question with their expert about basically, what would this case look like? How would this case look different if it actually had been because of the axe throwing? And that was Jessica who did that. That was really helpful because it painted a picture for me, right? Oh, he would have been dead already. You guys both on each side can do that with experts because they can do the hypotheses. And so, like, let's talk now. The plaintiff's saying that this is what happened. Like, what would that look like? Or the other side, kind of breaking it down when you have an expert who can give an opinion, right? And here you can do it as far as like what the, you know, you kind of were doing it with talking about like not having on the cross, like access to toxicology reports, and that might have informed what you would have told the person to do, and it kind of suggests that he didn't take his medication when he was supposed to. But think about how you can drag out one larger point, like alcohol. How can I drag that out and make it a picture that I can see? Or, you know, with the person who is treating going through all the things that they would recommend so that later on you're arguing closing all the things that can happen here that could have easily prevented what ultimately occurred. Does that make sense? Okay.
So I'll jump in here really briefly. So Jessica, I haven't had a specific thing for you yet. I said that Dan's best moment was his closing. Matilda's best moment was her cross. Your best moment was your demonstrative, and using that as a direct. It's interesting, and this is a very sincere compliment. When I looked through my notes when I was done, I never had a moment for you, but you know what? You got for me, the exact same score in every category, while everybody else zigzagged above you. So you brought a steadiness to this trial and just sort of a consistent, doing everything well. So, you may have never had that moment that they had at different points, but they also fell below you at other points. And so you've really got to embrace the fact that more than anyone in the room, you really brought it at every part. But you can also learn from all of them and make each one better, but you never had a weak moment. And I really, commend you on that. You just you went at it for 3 hours and you just got it done. So good job.
Thanks.
Something that Jessica did that I really liked as well was you were trying to kind of show the workload increasing, and then you got the objection and you were very quickly backed into it. And I think you showed a high level of being able to adapt to the objections, and I think that was very strong. Kind of going back, and I won't beat a dead horse, but this idea of showing what you're asking would have looked like. So with these kind of cases, you're always kind of like, well, what does the reasonable action look like? When you have the wife up there, you can say, so, after you saw him sweating, you saw him looking all white-faced, you didn't say, honey, let's go to the hospital now. You didn't call 911 yourself. The absence of actions are showing me, the listener, well, that would have been completely reasonable. Like, why wouldn't she have done that? And so that's like, you're using this kind of set of facts or the absence of facts, and you're making a picture of it, in that moment so you're going through and saying like, and then you saw him looking sweaty, and you saw this, didn't do this, didn't go to the hospital, didn't do it, go home, you guys have an argument, right? So you can kind of keep showing at many points she could have reasonably just done this and we wouldn't be here. It had nothing to do with the axe throwing. It was, something that if this 1 or 2 steps had been taken, could have been done. On your side, you're doing that with Jamie Gonzalez. And I think that, Daniel, you did do a good job of that when you were showing the tape barrier, when you were up there and saying, you can make it a bigger picture, right? So this is just to be clear, this is just a tape, right? There wasn't a chain fence, there was no one guarding, there was no one there saying to people they shouldn't cross this line. All we have is this tape. And those are proper questions that she has to say, no, they weren't there, no, that wasn't there, no, that wasn't there. And she can keep saying it wasn't legally required, or I didn't think it was necessary, or he shouldn't have stepped over, but you're painting a picture of what would have been reasonable, right?
And Madison, I misspoke. Your second best moment was your demonstrative. Something I alluded to earlier, your best moment was your objections. You made more than anybody, you were a total pain in their ass, and you won more than anybody. And that is exactly what objections should be. So great job on objections.
Oh, also
you won more than they made. So you nailed objections.
Also, when a person, if you don't have anything else to say, try to, if they're kind of getting into opinion testimony, but you're trying to say, well, that's what it looks like to her. If they're like, he was upset, right? Or he knew what medicine to take. Try to say something about rationally based perception, right? Based on their interactions. They're like little buzzwords that we know come from some rule somewhere, and it's like, oh, that sounds right. So try to remember those kind of buzzwords that you can use when you don't have anything else to say except for, come on, she's not saying that she was in his psyche, she's saying to him he looked upset, and I can lay that foundation. I think that on both sides you have witnesses who are going to elicit those kind of objections, and also you can dead them very easily. I also liked when there was a part where we were comparing, where you guys were clearly using the expert testimony, but I think especially Daniel did a good job of taking the testimony as it came out in the trial and incorporating that. I'm moving to closings now. Into the closing. And so I think that was one thing that both sides could improve on, but it was really nice to see that with the expert, to talk about kind of what their own expert was saying, and talking about the comparison of the prior events, the car accident and the divorce, and how no heart attack happened there. And this is the difference, is their actions. So I don't know how you guys work as far as collecting points or like trying to make it easier for the partner who's closing to take in those nuggets, but if there's a way to kind of track that, so that you can be using more of the exact words or things that came out during the testimony, I think that's a way to kind of build a stronger closing that seems more responsive to what happened in the trial as opposed to what you guys have already prepared before. And so with the closings, I thought your closing sounded like a defense closing because you started with all of their affirmative defenses and you spent the majority of your time talking about the affirmative defenses. And like Matilda said in the beginning, we have a burden and we embrace it. We're not scared, we like it. That's how you have to close. Because otherwise it sounds very like they've already conceded on some level the negligence aspect. And so what they're trying to do is distract me with how they didn't meet their affirmative defense burdens. Because if I hear that closing, what I'm going to do as the defense is stand up and say, plaintiff's counsel just came up and spent the majority of time talking about our case. Where did they show you that we were negligent, right? And so I think that you want to reframe your organization as the plaintiff. Start with yours. Let's start with some sob story. Let's have some tears. Let's have some emotion, right? Because we always have the dead person, right? And how that shapes why we're here. Start with that, get some momentum. That's a part that you don't have to relearn and reincorporate, and you can start with it, and it'll kind of help you get into your stride a little bit. And then you can get into plugging in things as they've come in. But you want to start with, this is how you know we've met our burden. And that's the larger part of your closing. And then I think it's fair to kind of try to say, to cast these affirmative defenses as distractions, right? You can say, now, of course, the defense is going to come here and point at everything but them as the reason for Mr. Fortunato's death. And we saw that, but you should dismiss it, and you should dismiss it quickly. And this is why, and just knock them out. Because I think that you have it, like, obviously, great. You have the document. You're like, he didn't even sign this himself, right? The lady came in here and she's not listed as the deli person. She's listed as the independent contractor who owns Hatchet, whatever, right? So like you have ways to hit it quickly and you use diagrams effectively in the closing and in the examination. But I think that the way that you framed how much time you spent made me think that they were on to something more than you actually want me to.
But Dan, I do want to though, and this is really student level stuff, but I want to give you just another, applaud in your closing. Things that I see with students, and maybe this is the cautiousness we teach you, in law school, is, the other three, maybe they are more right, but they just got into their rhythm. They're going to talk to the non-existent jury, and you decided you wouldn't. And to me, that took guts. In the same way that one of the weaker advocates I saw this weekend, and I happen to be in this room then too, simply decided that was the witness bench, okay? And so then there were advocates after that were scared. Oh my God, that must be the witness bench. And there were the ones who just simply had the conviction, no, like the witness goes here, okay? And they got their witness to go to the right place. And so I like that people aren't just like uber cautious. You gave the closing you wanted to give and the way you wanted to give it. And I just found that effective. And I would always encourage young advocates, on some level, you got to be you. And you weren't going to talk to a made-up jury, and for whatever reason. And I just like the fact that you didn't feel like I must do this, So I thought that was a very good thing. So
The other point to add to yours, Daniel, was I already mentioned about like using the expert testimony specifically, but also like I think that in these cases you're always asking, as I said, what the reasonable person would do, and here you were able to use parts of the case and make them seem so normal. Like, of course it's on his phone. Everybody's on their phone. That's not a big deal. That's not a stressor. That's not a stressor. Like,
And that was emotion. That was
it was, yeah.
finally
And
the
it
emotion.
just made sense. Like, obviously, that's not a big deal at all. That's not why he's here. When you talked about the physical barriers and how they could have been there, and if they were there, like, it just, you did a better job of painting the picture. And I thought that those were two examples where it just seemed like, oh, that's completely reasonable. Like, why are we even having this discussion? But then,
as much as I like that, I mean, I do want to say, where I very much agree with Lauren. You did start slow, where you were focused on not, but I just thought that's when you began to roll, when you were doing all that. Yes.
so I think the only other thing I'll say is that you have all these kind of common sense points, and you should change how you organize them. But at the end of the day, and that's why they're liable. Hold them accountable. Like, at the end of your first portion, you did not say hold them liable, hold them accountable, give him justice, anything like that. And then I thought you were going to do it in rebuttal, and you didn't do it then either. So we have to ask for what we want on both sides, but especially on the plaintiff side, who is asking for, like, you're asking for something, right? And I think that you have all the points, and you just have to finish it there. And that's another place to be, like, more emotional as well.
That's a colossal point for just lawyers in general. You guys get so caught up in the argument in the moment, you don't tell the court or even me when you're complaining about a judge in a competition what you want to happen. And if you don't give us at least something to aim toward, so yeah, that happens all the time.
So then with Jessica, I thought that I liked how you started about talking about how this won't bring justice to holding the wrong people accountable, won't bring justice. You used ordinary care, and I'm sure you guys hear about, like, triples, like repeating something 3 times and it stands out. And so you used ordinary care when you were saying, ordinary care would have been this, ordinary care was this, ordinary care was that. Because it was another way to kind of paint a picture and show how the plaintiff hadn't met their burden. I also thought you did a great job of attacking House's credibility in going through how she doesn't even know about the new stressors. She hasn't seen him in 4 months. She adds basically nothing to this. And then you were able to talk about the demeanor testimony that you had gotten from even direct of the wife, about how he was sweating before these things have even happened, how he had been upset earlier. I liked the point of putting together the testimony to say, like, if out of 36 people, you can hear 2, that means they had to be pretty loud, pretty upset. That was a very, like, it's like, oh yeah, you're right, because otherwise I didn't really care so much about 36 versus 2, but that was a good way of kind of piecing those things together.
But then to learn from each other, you and Dan at one point were making virtually the same, for your side, the same point of the demonstrative. Dan went over and showed us. You gave us this little arm thing, what I mean? You can break out of that, and you can go over. And again, it's probably imprecise, but that's what I mean by emotion. Give us something. It was just more effective to have someone walk over and point and show.
Yeah, and then I think some of the other things, like, that were hard were just because I'm not sure I would have taken on all the affirmative defenses. I think sometimes there's, like, a credibility issue that happens where when you take on everything, like, that the guy didn't sign the form himself, so it's going to be hard to be like, he assumed the risks, right? So maybe you don't take that one on, but that's not so much about your closing delivery. That's about, like, a harder path,
the whole trial,
right? Based on the strategy. But good job, and I also, you did say, we shouldn't be found liable, and that is, you also have seen all these affirmative defenses, so I think that was clear in your closing. So nice job, guys. These are, like, largely points to
try to make it a little better.
Yeah, to develop and for going forward. But really nice grasp of the facts.
She hopes to coach you all.
Yeah, I would love to. It'd be fun.
It's your show now.
Thank you, guys.
Yeah, thank you.
You're welcome.
Thank you.
We don't even know who won, so we're gonna find out now.
So, congratulations to the winners, the defense, Madison Cohen and Jessica Mugler. And the finalists, you also did a fantastic job throughout the entirety of your thing.
And are you guys 2Ls or 3Ls?
2 Ls.
They're all
2Ls.
2Ls.
So you get to wait a year and a half, and the day before graduation, you get a check from Wayne Cohen, but you get to wait a year and a half and no interest. But you know what?
We can't get it in advance.
No.
That's
That's
funny.
okay.
Thank you.
Thank you. Good job, guys.
We also have Best Oral Advocate Awards to give from Saturday's preliminary rounds. So for the first time since I've been here, at least, we have a tie for the best. So for the top two. So congratulations first to Henry Finkelstein. And the other, I guess, co-first place, Best Oral Advocate, is Jessica Mugler. And then the third Best Oral Advocate for the Cohen & Cohen competition this year is Hayden Howlett. And then there also are Georgetown Sprinkles cupcakes outside in the Kelly Lounge. So if everyone wants to come outside and just have a quick little reception, that'll be great.
She's just gonna give a quick photo with each team with Judge Lauren, not me.
Okay.
I'll organize it the way we do it. I'll move these two chairs, and you'll stand up here.
Wait, Kathy,
Really
should we get a picture?
Thank you.
If we get one, I'm sorry.
I guess I'll take one of you guys. She had to leave.
Oh, yeah.
Lauren had to leave. Noel had to leave.
If you want to have it.
Did you guys want to do it? Did you guys want to do it here?
Oh, I will be there.
Oh, okay.
Gary.
Okay. Oh, what was
Yeah.
that?
I'll be taking them up there. I will
Oh,
send them
okay.
to you. Yeah. Yeah.
Yeah, just
If you just
stand
step
on
up the
either side
stairs.
of her and just to get like both teams and
Yes.
then one team
Should we
side.
hold these?
Go on up. Then email me right away. Can you do
Yes.
that?
Yeah, thank you so much. Took a lot of time out of your day.
This is way more fun.
Well, that might.
And Kiss will kind of get you dead in the middle. We'll get
Yeah.
you. So everybody's got to
So
go a
if
little bit
you
that way.
step over a little, like probably
keep
2
going,
steps.
keep going.
One more.
Oh, close.
Almost. Yeah, right there. Okay.
You are a very difficult witness.
You can tell when I got flustered because I was like, huh, I don't think I know just because I just went.
No, you weren't focused on her. You got focused on her.
Yes, that was how you was internally panicking.
I'll go on this side.
Yeah.
Oh yeah, no, we were just counting.
Thanks, guys.
Thank you.
Congratulations.
Thank you.
Congratulations.
Thank you so much.
Yes, look at that grade.
T-Mobile.
I really do hope all 4 of you do an external. You were all really, really real. Or 2 externals. You were all really good.
Thank you.
That's so sweet of you guys.
Oh,
We're so proud of you. Oh, here's Mrs. still here.
Thank you so much.
Of course.
Thanks for the flowers.
Yeah, congratulations.
Thanks.
Good job.
Hi, Eugene. Thanks for coming.
This was much more fun than going to.
Did you skip?
I skipped because of that class and college.
Thank you here so much. It's so sweet. Wait, what's going on outside?
No, it was fun. though.
Okay, good, good. Please feel free to take a note.
Yeah.
This is what you're
Uh,
doing.
I know. Thing and just went like, I did it on purpose.
I did it. I love it. I knew it would fall off.
I trained for weeks studying at the
That would be so funny.
Sorry, I need to run soon. So you guys want
Yeah. Do you want to get a picture of that? Yeah. Here, I can take it. Okay.
No, no. Sorry, I'm just gonna think that way again. Are you hungry? Do you want to get food? You're so tall.
this is good breakfast.
No, I ate a
We have cupcakes outside.
I'm throwing them away.
I'll throw it away for you.
You wanna,
Yeah.
so,
This is for our moms. Me and my Cohen. Okay, are we in the middle? Like this?
Yeah, but I'll take it from back here so it's like more.
Okay.
Sorry about that, everybody. Now, how much have I walked into that?
Cute.
Maybe we should also get one outside.
Yeah, let's get one outside.
Okay.
Just what else did you win?
Best oral advocate, which is from the preliminary rounds,
That's
the
awesome.
scores, and then, yeah, and then for this rounds.
Or did you want me to save them for?
no.
Yeah.
And this round?
What are you doing?
I'm giving it to you, actually.
You're
It's
gonna
a
hang it on your
gift.
wall.
This is my birthday present?
Yeah, this is for you. You get to keep it forever. Happy birthday, free birthday.
We know it's what you wanted.
It is.
I will write you.
I'm gonna take it to class.
Maddie, do you want to leave stuff here real fast and take a photo and then come back?
Sure. Okay. Thank you.
Good luck in band luck.
Thanks.
God willing, I'm not judging you, but I will judge, whoever doesn't show up that morning,
Yeah.
and so I'm.
This is part of your duty.
Wherever.
As
Yeah.
a showrunner.
Did we get enough judges or no?
Also,
You're coming
well, we
tonight,
went
right?
through every room,
Oh.
just like a few have three as we get, it's really the same model
Are you
as,
coming?
As Cohen?
So spooky.
So yes, we have
Your class
many,
ends at what time,
many
9?
more judges
Okay, but
than you
we're
did.
starting at 8 though, so
Uh,
he's only missing an hour.
But we still choose, we haven't had the hemorrhage you've had so far, but I don't know what's happened all morning.
Yeah,
So, okay.